we will call to order the August 26, 2019 regular meeting. And Mr. Robach, will you lead us in the Pledge of Allegiance, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Moak, roll call, please.
Mrs. Buttermer? Here. Mr. Estes?
Here.
Mrs. Hill? Here. Mrs. D'Ambrosio? Here. Mr. Robach?
Here.
Mr. Curry? Dr. Bruno?
Here. We have tonight a very special opportunity, and that is to welcome new staff to District 31, and I will turn it over to our superintendent.
I would ask our Assistant Superintendent for Human Resources, Marcy Conlon, please come up and introduce our new staff members.
Okay, new staff, I'm going to read your names. You can just please stand once I read your names. And then everybody will sit down. Ann Nelson, Ben Franklin. Lauren Rusk, Ben Franklin. Kimberly Kirsten, Churchill. Brittany Roderick, Churchill. Carly Alfieri, Churchill. Leticia Carrera, Churchill. Nor Kajega.
We'll get it.
Forest Glen. Jamie Antonopoulos, Forest Glen. Megan Kemper, Forest Glen. Jessica Allison, Forest Glen. Alexandra Denny, Forest Glen. Randy Wynn, Forest Glen. Jillian McNamara, Forest Glen. Hillary Young, Forest Glen. Caitlin Krajik, Hadley. John Robinson, Hadley. Elizabeth Schultz, Hadley. Carolyn Peters, Hadley. Danielle Winters, Hadley. Haley Jefferson, Lincoln. Stephanie Dorsey, Lincoln and Franklin. And we have a new assistant principal, Amanda Connell, at Hadley.
A big collective applause for all of you.
Nick Papineau, he's our new PBO.
Oh, Nick!
Thank you, everyone, for coming, and I was asked to remind all of you, you do not have to stay for the full meeting. You're welcome to stay with us if you want to, but please feel free to go home and get some rest before you're here back early tomorrow morning.
Thank you.
Thank you.
What, you're not going to stay?
I wouldn't say.
Oh.
Choice.
Yeah, well done. Smart teachers.
All the way back.
Okay, thank you. Yeah, it's getting warm. The next item on our agenda is public participation. Members of the public who wish to address the board should complete the yellow public participation form and hand it to Mrs. Moak. Speakers are asked to maintain respectful decorum and limit comments to 3 minutes or less. Ms. Moak, is there anyone who would like to make public comment?
Jeff Cooper?
Thank you. Mr. Bruno, I can appreciate your clinging to your principles during your time frame at Westfield High School. Even in the face of your eventual firing, it appears that your principles were important to you. I'm assuming that these principles stayed with you through the years at Union County College and New York University. So I ask you, what happened for you to abandon your principles? What caused you to decide that any way possible was your new mantra? You're not sure what I'm talking about. I'll enlighten you. What I'm holding are pages from your application forms from May 1995 for a position at the U of I for a labor education assistant professor. What I don't see on these pages in the professional teaching, business, or other experience section is any reference to your job as a teacher at Westfield High School or your subsequent firing. You lied through your omission of an extremely pertinent part of your work history. Considering your principles, wouldn't you have been proud to have explained how you were wronged by the administration and the director and the board at this district? Or did you figure that honesty wasn't nearly as important as getting what you wanted, no matter how? We have our answer. You got the job. You buried your principles. We move forward over 20 years. When you ran for the school board, you actively hid your dark past. You never responded to my inquiries on your work history. And when finally confronted with your past, you called it irrelevant to your board work, as did your minion, Mr. Estes. This is the same man who wants 30 to 45 minutes of my time and attention, his words, in order for me to get a copy of the supposed article that he spoke of
30
at
seconds,
the last
Mr. Cooper.
board meeting. This lie on your application is a disgrace to you and the community, the stakeholders. You should step down now.
Thank you very much. Mrs. Moak, anyone else?
That's all I have.
All right, very good. The next item up on, well, I think we want to go to superintendent reports.
That's okay.
We're going to go to superintendent reports. Melissa?
Okay. At this time, I would like to acknowledge Mr. Dave
Oh,
Scarmato
there we go.
and thank him for the work that's been done this summer by Dave and his team, but most recently in these last couple weeks, getting the buildings ready for kids, and even more recently, the last few days, what it has taken to get our buildings ready for staff to come back and kids to come back requires nothing less than a superhuman effort. And some people have pulled together some pictures, and we would just invite people to sit back for a few minutes, take a minute, enjoy the pictures and the presentation, and when you can, give a big thank you to Dave and all of his crew.
I think you should be narrating, Dave. No? Picture say it all.
That's Steve's correct.
And now we have the after, huh? This is before.
There's room for Dunkin' and Starbucks.
We're all over as much coffee as we can.
Well, and Dave, I do want to acknowledge that. It's incredible when you see the before and then the after. And the before was actually somewhat close to the beginning, to the opening, and your team just did a phenomenal job, pushing really the envelope, making sacrifice to get the school ready. So hats off to all of those folks. Big acknowledgement to them. Thank you.
I just want to add, because I I know throughout the process, I've had a lot of questions for Eric, but it seems like he's also very instrumental in all the whole process with getting the finances all together, so I acknowledge that too.
Absolutely. I don't think anybody would dispute the stress that you see on people's face the last maybe 2 weeks when construction is wrapping up, and every day we'd have a meeting, or almost every day it seemed like, and talk about, are we going to be ready, are we going to be ready? And I would just watch Dave's face, and if you didn't look panicked, I wasn't going to panic. So, but I don't think anybody realizes that it means extremely long days, and just there's no way to describe the end of construction until you've lived through it, so thank you.
Thank you. Okay, very good. Now, tonight we have a set of special guests who are going to lead us in a professional development session, and I will again turn to Melissa to introduce our facilitators.
Righty. So with us tonight from Franzik PC is Brian Crowley, Dana Crumley, and Todd Faulkner. And I'm going to turn it over to your team, Todd, and let them lead us in the first step of our learning together.
Maybe we'll just take a seat in the front row over there, and we've got microphones. I don't, you're leading? It just means we won't worry about the microphones. Well, I think you can guess who we are.
Yes.
Todd Faulkner, Dana Crumley.
Hello.
Brian Crowley.
Nice to see you all.
Dana and Brian, I'm fortunate enough to call my partners. And, the three of us really probably handle very much of the work for the school district. And we've done this for quite some time, as I'll allude to in a few minutes. But we hope we have a semi-formal presentation to make to you tonight, and hopefully we can get that done in 20 minutes, half hour or so, and then use whatever time you'd like. And we have no fixed time. We know you've allocated about 90 minutes. Just to take questions, have discussion, and we'll try to answer the questions that we can. If there's some that we can't, we'll follow up on those. I think probably one important point to make at the outset is there's no cost for us being here tonight. This is a service that we offer to our clients.
So we put it, can we drop that down? Because it looks like it's got a thing you can just drop it and put it.
And maybe we can just put it in the middle.
It's just that we live stream these, and so they won't be able to hear you unless...
Well, we'll stand.
Well, perhaps we can drop it down. Maybe if we can drop the,
It didn't drop.
let's see.
Not strong enough.
So our calculation is free, but we want to get our money's worth.
Right, absolutely.
And is the light on?
Lights on.
Green light, okay.
Yeah.
Okay, we're good.
Is this working?
Yeah,
now?
thank you.
Okay, good.
Thank you, Mike.
Sorry, Sam.
There.
I have served as general counsel for the district for more than 35 years. And I'm also a nearly lifelong resident of District 41. I am a product, I hope a good one, of the school district, as is my wife, my children, and my grandchildren, several of my grandchildren. So obviously we have strong roots in the community, but I've been very privileged to serve the district as its general counsel for this long period of time, and look forward at your pleasure to many more years of service to the district. Our law firm started 25 years ago, and obviously 41 was a client of mine in my former law firm before we started the Franzik Law Firm. We have represent over 100 school districts in Illinois, ranging from some of the very largest in the district to one school districts. So a broad range of clients. We provide really a full spectrum of legal services to our school clients, with the exception of bond work. That's a highly specialized area that we think the district is best served both economically and in terms of expertise by bond lawyers. That's what they do. We try to act, very much in a collaborative way with our clients, and we've had that relationship, fortunately, with the district through the years. We find that it is extremely important that, say, we interact, that we are able to have full discussions with you, so that we can gather all the facts that that we need and understand the goals that the district has in whatever the legal problem might be, or related issues to the legal problem, and then to afford you a range of options through discussions. So we're, again, trying to recognize and achieve your goals to get you there in a path that is productive, minimizes legal costs, and is successful in achieving where the board would like to go. It's important to emphasize that we work really literally on a daily basis with Melissa and many of your administrators over there, and but we do emphasize that our client is the Board of Education, and that's where our responsibility is. We also work closely with the board president, but again, our responsibility is one collectively to the board, and it's rare that becomes important, but at times it does, and we're very mindful of where our responsibilities lie. I would just like to make a few comments about our approach to problems, expand on what I was just saying, really, and that is that it's important that we help you recognize legal problems and anticipate where legal problems might arise, and that's one of the reasons and part of the function that we're serving tonight. We also offer alerts on emerging legal issues. We offer an annual school law conference, which we encourage both the administration and board members to attend. And we've sponsored various webinars and other means of communication through modern methods to keep the district up to date in terms of developing legal issues, so that collectively we can identify issues and get at issues as early as possible. We find that the earlier that we can identify an issue, get a feel for what the issue is, and begin to give you advice and options, that the outcomes are almost always better and less expensive than if the problem develops, erupts, and then comes to us. And again, that's something that we place a lot of emphasis on, and pride ourselves in working collaboratively with clients in that fashion. So in that vein, there are no dumb questions. Sometimes we find oftentimes that a question that a board member or administrator is hesitant to ask becomes a key question, or a fact that a board member or an administrator relates to us that may seem insignificant turns out to be very important. And so that full communication and discussion is very, very important for us to deliver effective legal services to you, again, at keeping cost in mind. I'd like now to shift a little bit to a brief discussion of some school governance issues. And I guess we had distributed a manual that we had prepared, that we actually prepared over the years to you. And we are in the process of bringing that up to a 2019-20 version, but for the most part, it's accurate. And if we could we pull up page 1 on governance? What we've identified here is really the hierarchy of the legal structure that governs schools. And there's obviously, one could write books and books about each of these bullet points here. And I'd like to go through and just make a comment or two on these. And again, it's to try to hit some of the key principles to help you identify what do I need to think about as problems come to you as a board member. At the top of the hierarchy is the United States Constitution. The First Amendment, free speech, and religion issues pertain both to students and employees. In fact, all of these generally apply both to students and employees. But we also have First Amendment issues in terms of public participation, communications that the board or the district might make to the public, and so on. So we're always mindful of the First Amendment. The Fourth Amendment is not something we see too much anymore, but it does, you've all seen and heard about the cases in the criminal field that relate to searches and seizures. But those principles extend in a modified sense, a softened sense, to searches of students and employees. Again, not an issue that we see a great deal anymore, but it is an important issue. And the 14th Amendment, which is the one I want to expand on more than the other two, and that's the due process, the concept of due process that I'm sure you've all heard in many, many different contexts. But the essential elements of due process are that before something bad happens to a student, like expulsion or suspension, or to an employee, like a suspension or termination, or some other disciplinary action, due process is generally required. And if it's not required, absolutely, it's usually a good idea as a practical matter to extend due process. And because it adds an element of fairness to dealing both with students and with employees that is important, even though technically, in a legal sense, we might not have to do it. So it's good practice. But due process means that giving notice to the student or the employee what he or she has done wrong, and an opportunity to address the decision maker before the final decision is made and disciplinary action or adverse action is applied. And that's a concept that you always should keep in mind. If you question sometimes, why are we extending this opportunity for a hearing, or this opportunity for an employee or a student or a parent on behalf of the student to present something to the board or to the administration, usually it's because of due process, either because it's required or it's just good practice in terms of relationships with employees and students. Federal statutes and regulations.
I'll go right back to that real quick.
Sure, Jason.
And I've also heard due process brought up regarding special education issues, placement issues, those kind of things.
Right. And Dana will be...
That's a term of art. So
Okay.
when someone files a lawsuit in special ed, the initial lawsuit is called a due process hearing, or request for a due process hearing. But it is apt in its name because
Right.
it describes a more formalized hearing process that adheres to the concept that Todd's talking about.
And Dana works with your staff on most of the special education issues that you face, which, when I first started practicing, I don't even remember that there was a niche for special education. Today, probably 6, 7, 8 of our lawyers spend a good chunk of their time working on special ed areas. And the due process is not really constitutionally based, but it is based in the federal statutes and regulations. And it's a highly regulated, specialized area. They don't go into that in a little bit. The Illinois Constitution, in many respects, parallels the federal Constitution, and there are not a whole lot of issues. You don't see litigation typically that is focused or rooted in the Illinois Constitution. If it is, it's in conjunction with the federal Constitution claim on due process or First Amendment. But there are some important provisions in the Constitution, one of which authorizes school districts and other local governmental bodies to enter into intergovernmental cooperation agreements, in essence to exercise power together collectively, which the district does with the Park District, with other of our local governments in the area, and I think through some insurance cooperatives, if I remember, Eric. All of those are done under the authority of the Illinois Constitution. The Illinois Constitution also has a provision that speaks to the concept that public funds are to be used only for public purposes. In other words, public funds, the school district's funds, can't be helped or spent on private purposes or individual purposes. It all has to relate back to a school district or a public purpose in your expenditure. Doesn't come up very often, but again, it's an important principle that's embedded in the Illinois Constitution. The largest part of our regulations are in the Illinois statutes and agencies like the Illinois State Board of Education, the Illinois Educational Labor Relations Board, and there are a myriad of other agencies that touch school districts in many, many different ways. And we've identified a few of them here, but one of the important, I think, things to explain, just so that you have the concept of how all this interrelates, is that the Illinois Constitution contains a provision that says that local governmental bodies, like school districts, have only those powers which are granted to it by the legislature. And this stems literally from a court decision in the 1800s called Dillon's Rule. And it means that the school district needs to be able to look to a specific provision of the law, the statutes, in order to have the authority, to be able to point to it, to have the authority to act, or the board's action needs to sort of flow from or be very closely related to the statutory provision. Now, the Illinois legislature has taken Dillon's Rule a step further, and I think it's a good thing in that it contains, the school code contains a provision that in essence gives the board broad authority to take action that it deems appropriate for the operation of the school district. So the legislature has taken the constitutional provision, which is restrictive, and expanded it a bit. And so there's always an interplay between restrictions in the school code and the provisions of the school code that say that we can act more broadly. And that's something that, that we deal with, have to wrestle with in terms of when there's a question, well, can we do this? Or, how are we restricted in doing this? So we apply these principles as we look at the school code, as we answer your questions as to can we do this, and if so, how can we do it? So, at times we'll come back and we'll say, we don't think you can do it because the authority isn't there, or it's regulated in this way. But we try very, very hard to find ways to get you to where you want to be, obviously within the pathways that the statutes create. School board policies and regulations are, that brings the legislation down to the local level. And you subscribe to the Illinois Association of School Board Press Service, which by and large is it's a good and economical way to develop your policies. But we do want to caution you, or at least alert you, that the School Board Association develops policies that can be generalized or can be very, very conservative in a number of areas. And it's very important as you get the press publications, it's very important for you to read these carefully and to make sure that the provisions work for District 41, that they work in this district, and that the practices that you may have developed are either consistent with the policy that's being recommended or you modify the policy to fit your practices, assuming it's legally appropriate to do that. So it's a great service. It's economical, but it should be, what you get from press should be looked at very, very closely to make sure it fits. And we can help you tailor the policies as needed to fit the law. And sometimes we have a disagreement with the interpretation that are reflected in the School Board Association policies, and we usually find ways to alert you to where those disagreements might exist. I'll just give you an example. I was working with a school district over the past couple of weeks where there was a need for discipline of an administrator. And that school district had taken the press policy on its face, which did not provide for or permit the suspension without pay as a disciplinary tool. So, and we don't believe we believe you have that tool. That district had followed the press recommendation, and it locked itself out of a tool that would have been very appropriate to use in that particular situation. And we found a way to, do something that worked for the school district. But that's an example of where a policy that one gets from press probably doesn't fit good operations.
Can I ask, so in working with all the other school districts, is it then, I'm going to assume it's not uncommon that they'll have policy that might diverge a bit from press, but they might also have something that's homegrown. They may come up with policy that's independent of press, and that sounds like a good idea depending on the facts.
Yes.
You're all
I mean, this policies are the board's governance tools, and they need to fit the way to your vision, your administrative vision of how the district should operate. Again, within the larger bounds of the hierarchy that we're showing up there. And last, we have contracts, including collective bargaining agreements with our employee unions, and those agreements are very, very important. It's important that you as a board have a general working knowledge. It's critical that the administration have a very detailed working knowledge, which I know that they do from the conversations that we have from time to time. But it's in looking at a collective bargaining agreement, sometimes the view of board members and administrations are that, particularly more board members than administrators, is that we need to be able to look to the collective bargaining agreement for authority to do something. And that's really not the role of a collective bargaining agreement. It acts more as a restriction on how the board is going to deal with certain issues of compensation, discipline, leaves. I mean, they spell things out, but in the absence of a restriction in a collective bargaining agreement, the board is really free within the hierarchy that we're talking about to act the way it believes in the best interests of the school district. And this is important. The other corollary to that, though, is if just because something isn't covered or restricted in a collective bargaining agreement, the board may still have the obligation under the Illinois Educational Labor Relations Act to interact with the union, to let the union know what might be coming, to bargain or have discussion with the union on a particular topic, even though it may not have to go into a collective bargaining agreement, or even though it's not in a collective bargaining agreement. So as you deal with employee and employee group issues, we always need to keep in mind, what does a collective bargaining agreement say? Does it restrict us in some way? And what obligations do we have to deal with and address, and ideally work cooperatively with the union to implement what the board wishes to do. I think at this point, we'll come back to some of the, I think there are some questions that have been posed. We'll come back to or cover as Brian and Dana will talk a little bit about confidentiality and some of the other issues that go along. So I'm going to pass That's to the best of Brian, I think. Yeah. Any questions for me before we do that? And again, just if anything strikes you sideways or you have a follow-up question, just interject.
Hi, everyone. I'm
Hey,
Brian
Brian.
Crowley. I deal with a lot of your FOIA and OMA issues. I'm on the phone with Nancy a lot. Right? So, anyway, so let's first hit FOIA. I have about 10 to 15 minutes, so I could talk about each of these topics probably for an hour and a half. So I'm going to hit on a very high level, and then I know you're going to have questions that are probably specific to your district. And I'm happy to answer those. I think we'll do that either after our presentation, but if you want to interject, no problem. So regarding the FOIA, I actually had a client come in the other day who works in the private sector, and he said to me, he said, Brian, how broad is FOIA? So this is how broad FOIA is. This is what it applies to. All records, reports, forms, writings, letters, memoranda, books, papers, maps, photographs, microfilms, cards, tapes, recordings, electric data processing records, electronic communications, recorded information, and all other documentary materials pertaining to the transaction of public business, regardless of physical form or characteristics, having been prepared by or for, or having been or being used by or received by, in the possession of, or under the control of any public body. I did that without reading. And so it's broad. It's extraordinarily broad. And especially on the board side, many of you, I'm assuming, are from the private sector, and it can be a cause of real frustration that FOIA is actually that broad. But as board members, you're actually not dealing with it on a day-to-day basis. That's what your FOIA officers are for. So with that said, there are three things where I would say you have to be concerned. One, you have to appoint a FOIA officer who's dealing with all the logistics, how to respond properly, etc. That's not something that you need to worry about. The second issue is at each board meeting, and either it's happened, I got here a little bit later, it's either happened or it's going to happen, where your board president or your superintendent will report on any FOIAs that are before you right now, the status of them. Third, most importantly, you as board members create FOIA-able documents. And where that's especially true in this day and age tend to be emails and text messages. And there's a very interesting case that is out there that's a few years old that has given us some guardrails on what that means. So what does it mean when you actually create a FOIA-able document? So the real easy one is if you are using your school district 41 email address and you are talking about public information, the transaction of public business, easy. That is subject to FOIA, period. You're talking to all other board members, you're talking to a resident, you're using that if you're using that email address and talking about public business, subject to FOIA. The interesting part is when we're dealing with our private email address or text messaging with a private, with your own device. So there, the court in Champaign came out with a decision that said if it's between a majority of a quorum of board members, meaning 3 or more, committee will get into that in a moment for the Open Meetings Act, it's subject to FOIA. And 2, if you are text messaging during a board meeting, that is also subject to FOIA. Now, with that said, there's all kinds of exemptions that may apply. But before I jump into those, I would encourage you, even though there's maybe law out there that would suggest that if you use your private device or use a private email to talk about public information, I would encourage you against using that. And the reason being is that you've been subject to these FOIAs before where someone will say, I want to see all about Bruno's emails. And what would be very nice is for Mr. Bruno to come to Nancy and say, I never use my private email address for public information. We could just stop the search there. But if you have, then we got to look at that stuff. So just have a real line as far as when you use your email for public information, it should only be your public address. Now, yeah, sure.
So let's say you get somebody that just says, hey, I know you, we shoot an email to you at your personal address, because I know you. How do you handle that?
So your personal address and it's a public information?
Yeah, somebody like, I coach your kid in basketball. So
I would, so if someone's done it prior, I would say, from now on, please don't respond to me this way. Now, I would say there's a good argument it's only going to you, and it's a resident, or you're a neighbor who's not affiliated with the school district, and the school district doesn't otherwise have that email. Under current law, that's likely not a public record. But I would immediately notify that person and say, hey, if you want to communicate to me again about school district business, utilize this email. Make sense? Yeah, okay.
But the key is school district business, too.
Yeah.
I mean, if it
Oh,
was...
no.
Yeah.
Yeah.
I copied Nancy on the response.
Right. So, and then as far as exemptions that would typically apply to the emails that you're creating would be pre-decisional. That's an exemption that we use. Let me get the right language here. So that's where you're expressing opinions or policies or actions are formulated. So if you're deciding on a new district policy and you're talking back and forth, and we'll get into the Open Meetings Act implications of that for a moment, but that's likely exempt before you come to a final decision. If you're reaching out to me or Todd or Dana about something, that's attorney-client privilege. That would also be exempt. Personal matters, if it's going into unwarranted invasions of personal privacy, that would be exempt. And then finally, if a parent is reaching out to you and wants to talk to you about their child, that would be exempt as well under the Student Record Act. So those are the big ticket item exemptions, also collective bargaining as well. There's a myriad of others. I think the letters go up to double P or something like that in the statute, but those are the big ones. So I move on to the Open Meetings Act. This is something that hopefully you've all been trained on, which I think all of you should have been by now. But this is something that we're operating under all the time. We're operating under as we speak. We are subject to the Open Meetings Act right now. And really, I could go on for an hour and a half about all the nuances regarding the Open Meetings Act. And in fact, I will encourage you, in November, the III Conference, I put out a presentation for ISB on the Open Meetings Act. It's for board presidents, but board members are more than welcome to come as well. And it's a pretty fun presentation. It goes on for about a little over an hour. We have fun. But so I would encourage you to do that. But in the meantime, here I actually reached out this morning to the public access counselor. So when there is, and I'm jumping around a little bit, but when there's an appeal regarding the Open Meetings Act or FOIA, if someone disagrees with what you've done, an appeal can go to the public access counselor. Hopefully we're all aware of that. And they make binding and non-binding decisions on Open Meetings Act and FOIA issues. So I have a really good relationship with them because I'm on the phone with them all the time. And I asked them to tell me the 3 big issues that they see where they see boards make mistakes regarding the Open Meetings Act. And they were pretty quick with their response. And number 1 was closed session. That's where they see the vast amount of complaints. And it's everything from going into closed session properly. So hopefully we do it right here, but when you go into closed session, you need to state in open session why you're going in. As we should know, there's a number of exceptions, litigation, specific matters about personnel, collective bargaining. And when we go into closed session, we need to state those on the record, so it's on the minutes, and then you all need to provide a roll call vote on that. We can then go into closed session, but we are limited to those topics then in closed session. And this is where they see the most issues, are where we're human beings, we tend to divert the conversation. And we're talking about a certain personnel matter, and it leads to something else. So you need to be very careful and stay on that path. Now, something else that could happen is we've said we're going to go in for an actual personnel matter, and we said, well, what about that litigation matter that we want to talk about? If you didn't go into closed session properly beforehand and say litigation's included in this, you actually need to go out of closed session, back into open session and say, we're going back in for litigation as well. Another closed session segment that they pointed out is a lot of times you might need to act on let's say a personnel matter where we're making a determination if we're going to dismiss someone or not, or how we're going to discipline them. And we'd like to act at that very meeting. So we don't know where the board is on it yet. So we go into closed session, we discuss the matter, and we'd like to come out of closed session and act. But many times when a lot of district or public bodies make a mistake on is they don't have that properly on the agenda. So we have our closed session, we're going to talk about an employment matter, we decide we're going to fire somebody, we come out and we fire them. But it wasn't on the agenda, and actually that's improper. So if we have a sense of how we may act at that meeting, it's essential that the agenda provide a guide to the public as far as how you may act on that matter. If you have no idea and you don't want to put it on the agenda, you just have to wait till a later meeting to actually take that action.
Brian, let me jump in here a little bit. And we're balancing a couple interests there. One is what Brian has just expressed in terms of the Open Meetings Act to give the public a sense of what we're going to be acting on and have it on the public agenda with the confidentiality and due process that we need to afford to an employee, say, in a discipline matter. So we've been successful in having a description for the agenda which allows you to take action but doesn't disclose so much that that it indicates that the board somehow had made up its mind before you had the closed session discussion and the hearing with the employee, and also doesn't identify the employee because you may not take that action, or you may take different action. So there's a balance there, which we think we can strike the right balance, and we'll work with you as you develop the agenda to be sure that you can take the action, but that we don't compromise the rights and interests of the employee.
Makes sense?
Yeah.
The second issue the PAC brought up is actually right on point as far as just agenda items in general. Being precise in the agenda, being specific enough for the community to know what you're actually acting upon. So for example, we can't just have on the agenda approve agreement. We need more detail on that. Approving employment agreement with the superintendent. That's something that's come up. The final one is what they termed illegal meetings. So as a board, the Open Meetings Act applies when a majority of a quorum is discussing public business contemporaneously. A majority of a quorum for 7 board members is 3. If you have committees, which I know you do, if they're smaller than 7, let's say you have a 3-member committee, 2 is the majority of the quorum. So if we have a building and grounds subcommittee made up of only 3 people, and they're having coffee one day and they're talking about buildings and ground issues, that may technically be a violation of the Open Meetings Act. Where the PAC has seen this come up a lot is good old emails and text messages, where board members are going back and forth on emails, and they're talking about public business. There's more than a majority of a quorum on the email, and you may have implicated the Open Meetings Act there, if it's contemporaneous, though. Now, again, my recommendation is let's not have a conversation over email, period, even if it's an hour and a half between emails, even if it's a few days in between emails. Let's just stay far away from it. That's an issue that the PAC brought up as well, so those were the 3. Good? Yes?
Yeah, so how about a little guidance having to do with participation during board committee meetings, and fellow board members jump in here if you need to clarify or excavate this a bit. So we have a committee, there's 2 board members on the committee. We filed an agenda, right? There are minutes. Other board members are very much interested in the conversation. They're not on the committee. They show up at the meeting. They are just participants in the audience. They remain quiet, can't participate, or they participate the way others would participate, but they don't vote. They're not part of the. Can you talk a bit?
Sure. So give me the size of the committee is just 2 board members. No one else is on the committee.
Let's say it's 3.
Yeah, sure. We can go with 2.
3 members.
Yeah. So
It's an open meeting.
And it's an open meeting.
It's an open meeting.
Yeah,
What I wanted to get at, I'm sorry to go off on a tangent a bit. I think one place of confusion, I'll get to your question in a moment. One place of confusion, I think, on committees is, let's say you appoint a finance committee, and you put 2 board members on it, and you put Eric on it, and you put a member of a resident on it. That committee is 4 people. The fact that everyone's equal on that. Do you follow me?
Yeah.
Okay, see, a board member is just as equal as Eric on that committee.
Okay.
So, but to your question, if it's just a committee of 2 board members,
right,
and 2 other board members show up, I mean, we may have a technical meeting of the board then, right? And Todd, I'd be interested in your thoughts on this as well. But my feeling is that's a highly technical potential violation of the Open Meetings Act. At the end of the day, though, because you haven't noticed it up as a board meeting,
right?
But you have noticed it up as a committee meeting, and it's open to the public, and you're taking minutes, and you're having public participation. So my sense is, and I have not seen a decision by the Public Access Counselor or a court on that. My sense is what they may say, because they tend to be pretty conservative on their reading of the Open Meeting Act, is, maybe a technical violation, not there, don't do it again. So probably the safest approach is if board members are interested in that meeting, no problem with showing up, but maybe just don't talk. If they do, there's a potential technical violation of the Open Meetings Act because we haven't noticed it up as a board meeting. But we have noticed it up, so I don't have a lot of heartburn about it.
I would argue that, from a more conservative point of view, I would argue that that is not just a technical but is a violation of the Open Meetings Act. When the previous board was on, we took great pains to not have more than 2 board members in a meeting at once. I mean, I think once or twice there was something where during the committee, to build the new addition here, there might have been 2 board members here that wanted to listen to the committee, but then the other person would go out and deliberately not hear that section of the meeting.
But there's still 20 people in the meeting?
Huh?
How many board members would still be in the meeting?
2 board members would be in the meeting, okay? And the other board member would be outside the meeting intentionally, so that the Opens Meeting Act, the OMA, there would be no violation of the OMA, okay? So we weren't going to go technically into it. We were going to follow OMA to the letter of the law, because we believed in, being open about what we were talking about. Now, at that point, someone would go back out and not know what happened, and if somebody had a question, they might come back in and ask that person who was there that question. But it was very intentional, and we weren't trying to technically break the meeting. We were not breaking the Open Meetings Act.
I think what we've identified really are 3 gradations or 3 scenarios here. One would be what Bruce just articulated, which clearly would not implicate the OMA. The second, sort of the middle gradation, is where we have board members who are not among members of the committee, but are in the audience and don't participate at all. They listen, and they don't even, really the better practice is that if you've got that situation, they don't sit together either. And then you've got the third is where the board members actually participate. And I think when we say technical violation, part of what that implicates is that what if the Attorney General finds that it shouldn't be done that way? What are they going to do about it? And usually where there's a technical, not bad faith violation, they will say, look, it should have been done differently, don't do it again. But I think our comfort level, certainly comfortable with what Bruce outlined. I think we have a reasonable degree of comfort with the middle option.
I'm not comfortable with that at all.
No, this is something for you to...
I think you said before that we weren't going to go down that path. In previous boards, I thought you counseled them to say that having someone in this meeting makes it look, you shouldn't even have that appearance of not being open.
I think I remember the conversation, I'm sorry, it's about the optics of it, and then, at least for me, I think about, well, there's an optic of perhaps an OMA, and then now where somebody files a, I don't know what the word would be for, but then you have to then involve our lawyer, and now there's costs associated with something that we could avoid ahead of time if we're I guess you would call it conservatively, not even having that optic of, possible OMA. So I think that's what we're, at least in previous board, I felt we were coached to really be cognizant of it. So is that what you were kind of speaking of, the optics of it? And that was my take.
I saw something in change policy where I think it was indicated that the board president wanted to be at any meeting he wanted to show up to. And I'm completely against that.
So let me...
I think it breaks the OMA. I think it's a clear OMA violation.
So
I wouldn't want to be a participant.
Let me be clear.
I wouldn't want to spend the legal fees in trying to fight that with whoever you fight.
What's important is to be very clear in your as far as the setup of your committees. So many boards of education on their committees provide. It's made up of 2 board members and the board president may attend. Hence, the board president is part of that committee.
Isn't that an OMA violation?
No, because they're part of the committee.
That was actually going to be my next question. And since I put the scenario out there, obviously, I knew that it would reflect on some different perspectives, so that's why you're here. I hear the response about what is clearly not an OMA violation. I understand the comfort level with the second scenario and the more problematic issue with the third, and it's something for the board to decide what they would be comfortable with. But then there is this question, and you anticipated it, actually Bruce mentioned it. Our policy, it's not a change in policy, our policy does include the board president as an ex officio member of committees and non-voting member. That's in the policy. There's been no change. It's been there for I don't know how long it's been there. But the question is, if that's in the policy, then the board president can participate. I'm assuming ex officio doesn't vote. Is that what it means? Like, what are the limitations to doing that? And is that, and you're saying that's consistent?
You don't vote at a committee anyway.
Well, that's right, you don't vote, that's right. So I'm not sure what, I think
It
it's...
depends on some
I think it's
committees
worded-
provide recommendations
Okay,
and such,
that's
yeah.
right, maybe that's
Yeah.
it. There was no vote, that's correct, thank you.
There's nothing that precludes committees from voting, though.
Right.
Okay, so it's...
But you typically are not taking any sort of final action, so there might be a recommendation to the board.
Okay, so
It sounds like
maybe
your
something-
culture...
Between recommendations.
Right, it sounds like your culture is to have a conversation, we talk about it, we don't actually have a formal vote, and it goes to the board. But if the board president is an ex officio member of each of those committees, he or she is a member of that committee, and there's no violation of the Open Meetings Act.
Okay.
And I want to emphasize, so I just want to make sure, and the committee meaning a board committee which has been posted and there's agenda. So we have superintendent committees, so with that does not, then you couldn't have basically 3 members
Yeah,
in that
Brian
superintendent.
will touch on the distinction between
Okay.
board committees and superintendent or other committees.
So subject to the Open Meetings Act are a public body, which you are, and any subsidiary body of the public body. So when you appoint committees, the board does, that committee is subject to the Open Meetings Act, period. The superintendent, if the superintendent appoints her own committee, which is reporting to her, and she's reporting, it's reporting to her, they are not subject to the Open Meetings Act unless the superintendent made a mistake and put 3 board members on it. Then it would be. So you got to make sure of your membership on that.
So if it's 2 board members, it's fine, it's not subject to order.
Yeah, I mean, some of the other nuances to that, the answer to that question are that the superintendent's committee needs to report to the superintendent and to assist the superintendent in formulating recommendations and actions that Melissa would then recommend to the board. It really has to focus and provide advice to Melissa, not to the board. And also, the board it genuinely should be Melissa's committee in terms of the selection and appointment of people. If the board gets its fingers into the selection of the committee members, we begin to drift into, it's starting to look like a board committee as opposed to a superintendent's committee. So it's really important to keep these distinctions in mind, to look at the purposes and the reporting responsibilities of a superintendent's or administrative committee.
Can I just add something quickly? And this is not, I am not as much of an expert as my partners here in these matters, but I have
Let me
sort of...
add something. Dana, you're the president
I've
of
been
the
the president.
Winnetka School Board, so...
I have served on a public school board for 8 years, and I was the president of the Board of Education in the Winnetka Public Schools, which feeds into New Trier. So I think that the thing that I think is most important, or one of the most important things, is not only to be mindful of the laws that Brian and Todd are explaining, and the differences between the types of committees, but by policy, you can determine how your committees are set up, right? So we actually went through a period which was very traumatic for the community, where we had to redistrict some of the elementary schools, and that traditionally would have been done through a committee process, but we determined that for that period of time, we were not going to have committees. We were just going to do everything as a whole board and notice up board meetings. Whereas in a less tumultuous time, with less tumultuous topics facing then we would go back to the committee structure. And your policies can be amended to allow for different types of structures as the needs of the district require, as long as you're open about those policies and you adopt those policies properly. So I think that's another thing to keep in mind, is that there's a lot of like consternation or conflict about things that the committees are taking action on. Is sometimes maybe we don't need a committee for this. Maybe we should just all, maybe this is important enough that we all just call a meeting and we address this, either through a special meeting or making a point on the agenda in one of our regular meetings, or we devote a chunk of time to it. So those are options. I just think it's important to always know your options.
Good. Good to know.
I have sort of a related question. Can you listen?
Oh, go ahead.
I'm sharing. So obviously, as board members, we're very involved in community, and there may be occasions where there's a school-related event where the board members would normally attend and be part of the conversation, but now we're on the board. And one of us is a board rep, but the other people that are there are just there because they always go, because that's the thing and it's a discussion. And it's not typically, it's not board business, but it's things that could touch the board because it's school-related, right? Because most of us are parents. I've been in a situation where I was told nobody can talk because there's more than 3 of you in the room, and this hasn't been a posted meeting, but it's like, well, the 2 of us would normally be here, the 3rd one is here because they are assigned.
Are we talking about like an open house event, or an event where there's actual speakers and people are listening and there's a conversation going on?
Like a PTA meeting or a coffee and conversation about a particular topic.
Yeah, I mean, if there are more than 2 of you there, I'd be careful about that. And either it kind of goes back to our last answer, right? Either don't talk, or just make sure only 2 are in the room.
I think you have to designate who is going as a parent and who is going as a board representative. Sometimes you're just going to go as a parent.
Well, that's my question, though. You can't just say, or can you? Because it sounds what you're inferring, is that 2 of us could say, well, I'm just here as a parent, I'm not here as a board member, but that seems...
Well, if it's an open house or a PTA meeting, you're allowed to attend in the interest of your own child and the interest of your own family. But as far as speaking on behalf of the board or going into a corner with the other 2 board members that are present, you shouldn't be having a conversation about board business. You can certainly talk to each other about the Cubs score, who has good coffee, whatever, but you shouldn't be having a board business discussion at the meeting between more than 2 board members.
The Open Meetings Act focuses on discussion among board members. And so if the scenario is, let's say we have 3 board members sitting in different parts of the meeting room, and they begin to, one board member says something, another board member stands up and responds, so that now the communication is starting to go between board members. That has a much greater potential to be an Open Meetings Act violation, where we've got 3 board members engaged in discussion of school business where they're interacting with each other. If their interaction is directed to the chair or the speaker of the meeting and they're not responding to each other, we've got a much stronger argument that that's not an Open Meetings Act violation.
Your question comes up actually from a lot of school districts. They'll see that coming, a significant meeting, and our typical advice is, can we only have 2 there? They say, no, we have a few board members and they're committed to going to this meeting, they want to go, then we say, as Todd just suggested, let's have one sit over here, let's have one sit over here, let's have one sit over here, and don't talk.
And don't interact. Don't interact getting together. Don't interact in your conversation, so that, Jess, you say something, and Ted's there, and Ted says, well, I want to add to what Jessica was saying. That's where we are going to drift into problems.
But the issue isn't whether or not, if Jessica says, hey, for that fundraiser for the build a new Gaga pit at the playground, I think we should do this. And Ted says, I think this might be a better way to raise money for that Gaga pit. And if we're talking about PTA business, I'm just using that as an example. Is that okay? And we're just talking about parents and...
Yeah, but it's the school.
It is
Yeah,
still the
yeah.
school, and
We're
it's
still
still,
talking
yeah.
something that's going to impact the school. It would be better for Ted not to react to what Jess says.
To make a different point, if he wanted to make a different point, make a different point.
And if a point on the topic is going to be made, definitely direct it, not to Jess, but direct it to whoever's
The chair, the facilitator.
chairing that discussion. But again, it's, you know, it's rare that you really have to say something. I mean, you know, it's good to be there. It shows community and PTA support. You want to be knowledgeable about what's happening. But you know, despite that, often we understand the compulsion to say something, but listening serves a lot of purposes as well and keeps us limited risk and exposure on OMA violations.
So, can I ask a question? A non-voting ex officio member of all school board committees. So, what do you have to be, you have to have an agenda for one of those
Committee meetings, correct.
And the agenda minutes have to be published? For distribution of the rest of the board, I would assume, so we kind of know.
And the public.
And the public, so that we kind of know what went on in the meeting.
Right.
And
The meeting has to be noticed up, same as
2 days
your
ahead of
board meetings.
time.
Right.
48 hours.
Okay. And then pretty much anything can be discussed as long as it's finance committee, if it's finance related, if it's policy meetings, policy
Agenda.
related.
Yeah, Bruce, you raise a real good question and point is, you know, for a board, we have basically 2 types of meetings. We have regular meetings and we have special meetings. And while you can't take action on an item at a regular meeting, if it's not on the agenda, you can discuss virtually anything at a regular meeting, even if it's not on the agenda. At a special meeting, you're limited to the topics in the call of the meeting, and you can't go beyond that. You really can't have an other
And these
at
are
a
considered
meeting.
special meetings, essentially.
Well, and that's the question, is a committee meeting a special meeting or a regular meeting? Some districts have a regular meeting schedule for committees. And I think, again, depending on how these are set up, you could make a pretty good argument that those are regular committee meetings at which any topic germane to the charge of the committee could be discussed. If the meetings are irregular, you know, the argument might be that those are special meetings of a particular committee, and you'd be limited to the topics on the agenda for that published meeting. That would be the safer approach to committee meetings. In essence, as you set up the committees, you would say, here's a committee, a board committee, and these are its regular meeting dates. And then you've got more latitude in terms of what can be discussed. If you don't do that, and it's sort of periodic, probably better to look at them as special committee meetings and limit the discussion of the topics on the agenda that's published for the meeting. Is that responsive to it?
Okay. Should we move off the OMA for a moment?
Go for it.
Okay. Well, we can come back to it, absolutely. So, final topic I wanted to discuss is board member ethics. So when you became board members, you are now subject to a number of new laws, so congratulations. One of them is the State Ethics Act. Under the State Ethics Act, there's 2 provisions there that you need to be concerned about, and you can't engage, one is you can't engage in certain prohibited political activities. 2 examples of that are you couldn't require an employee to work for your campaign for school board member. You cannot use school district resources for political purposes. That would be a violation of that act. The second one is the Gift Ban Act. You are prohibited from accepting a gift of over $100 from a prohibited source. There's a number of exceptions to that. That's in a 1-year period. The halcyon days of board members going out on golf outings and dinners and being wine and dined is long, long gone. So although we'd love to take you to the Cubs game, we can't. Sorry. We are a prohibited source as well, as are your architects, your various vendors, and anyone who wants to do business with the school district. So that's something you have to be mindful of as well, although there are exceptions, which are questions that I can answer. Finally, also you have to be mindful of conflicts of interest. So you cannot have an interest in a contract with the school district. So an example would be if you have a landscaping company, let's say, and you are the owner of that landscaping company, and you are the best landscaping company in Glen Ellyn, the cheapest, there's no doubt that the school district should go with you. Not only can you not vote on that contract if it's before the board, the school district cannot even have a contract with that company. Now, there are exceptions to that. If you are an employee of the landscaping company, we could have a contract with you. Or if you have a very low financial interest, I think it's about 7.5%, there's exceptions to that as well. But that's something to be mindful of too, because not only we can't have the contract, but also the contract is void. You are actually also off the board, and there's potential criminal consequences with that as well.
Not only criminal consequences, but felony criminal consequences. So I think the takeaway on ethics issues, interest in contract issues, and confidentiality issues is that if there's a remote question, ask, talk to Melissa, talk to Bob. They'll make a judgment as to whether we should be brought in. This is not an area where you want to take risks.
I'll just ask a question just because I've asked it before, but I'll just ask it. So, and I see it from time to time get on the check registers or what have you. Just clients that I represent doing business with the district, you said that's not an issue.
Generally not.
Right. I mean, obviously, if it was, like say referendum work, there's one of my contractors bidding on it, I wouldn't want to vote on something like that, but.
Right. You don't have, generally speaking, don't have the key is,
right.
The conflict piece is economic interest, and you have an economic interest in doing business with that, but you don't have an economic interest in that client's an ownership interest. Brian,
I agree with that. I think but to that point, there's also the concept of appearance of impropriety.
Right.
And I think in that context, although not a statutory conflict of interest where we can't even have an agreement with that company, if you feel something smells a little bit off, contact us. We can talk about it. And then probably the best approach is for you to, on the record, say, I have this potential interest, I'm not going to vote on it, so the public's aware of that. One example would be, actually this comes up a lot, in Illinois, spousal property is considered separate. So actually, if any of you are married to a teacher in Glen Ellyn 41, you technically are allowed to vote on the collective bargaining agreement. But that might not look so good because that's your spouse. So in that sort of situation, in that sort of situation, it would make sense to say, by the way, my spouse is a teacher with 41, I'm not going to vote on this contract.
Can I ask
there are two, I'll come back to you, Linda, in just a minute. There are two legal concepts here. There are common law conflict of interests, and there are the statutory conflict of interests, which Brian was primarily speaking to. With the statutory conflict of interest, generally speaking, you cannot avoid the conflict, if it exists, by disclosure and recusal. If it's a common law conflict, which gets more to the part of the smell test in essence, you can resolve the conflict by disclosure and recusal, but you don't have to get off the board. If it's a statutory conflict and you don't fit within an exception, you can't stay on the board. So, again, the point, if it doesn't feel right, there's a tinge of a bad smell to it, or it might be attributed to it, ask. Let's take a look at it and deal with the problem. Again, it's a good example of dealing with the problem up front, not after it's become a controversy.
I just wanted to hit on one last matter. You also, as board members, take an oath, and you are subject to a certain code of conduct under your policy. And the code of conduct is adopted by almost all school districts. It has about 15 items. I'll read a few quick ones here. You're to avoid conflicts of interest and appearances of impropriety. You're to abide by majority decisions of the board. You're to respect the confidentiality of privileged information. You're to prepare for, attend, and actively participate in meetings. You can strive for positive working relationships. There's a number of others. Something that sometimes comes up with boards is there may be a bad acting board member who is not respecting confidentiality, let's say. And unfortunately, as a board, in those situations, you actually have very little authority regarding the discipline of a bad acting board member. If it rises to the level of a complete dereliction of duty, you have the ability to go to the regional superintendent and ask for that individual to be removed. That has rarely, if ever, happened. I don't know if you've ever dealt with that. I know I have not. Where it does come up is if someone's just not showing up to meetings. It's been a year and they haven't gone to any meetings. That's where I've heard of board members being removed. But other than that, it's rare that the regional superintendent will remove it, and it makes sense. This is someone who is elected by the public. Some school boards have asked us to help them with, in those sort of situations, with a resolution to censure a board member. Those are what are known as paper tiger documents. They have very little teeth at all, and no real enforcement ability. The purpose of them is really to embarrass and to put someone on notice that the board is not happy with them. But there's very little you can do with that. And with that said, in the confidentiality room, there's actually an attorney general opinion where a public body had a board member who shared confidential information from closed session. The board passed a censure resolution, and the attorney general came back and said, in that context, board, you had no authority to even pass that resolution. So there's unfortunately, very little authority that a board has to discipline its own board member. That's all I have.
I need some clarification.
Yeah, Linda, I'm sorry.
Oh, yeah. I want to go back to what, Jason, you were saying. I need some clarification that when you're saying you're representing, well, I'm sorry, I don't want to put a spotlight, I guess. But let's say if a board member does do work with, let's say, let's just say like FQC or something, because we've seen a lot here. And they do work with FQC, but not directly with D41, so that wouldn't be economic interest. But I guess I see that if, say, a person is working FQC through FQC and gaining some revenue through D41 work, wouldn't that be economic? That would be having some economic gain.
Yeah, I'm sorry, what's the entity that you're...
So let's just say...
He's all up on my question. And so to my situation, I'll tell you exactly what it is. So I represent a client, I represent multiple clients, but I represent a client that happens, unbeknownst to me, happens to do work with the district. Nothing, I haven't done any work with that client regarding its work with the district, not involved with it in any manner whatsoever. But given the fact that they're doing work with the district, we write their checks, they show up on the check register, we have to approve that. And it was a question I asked early on when I noticed it, said, hey, this is a client of mine, is it possible for me to go to this check register, given the fact that we work with this client? Time said, yes, it's not a problem whatsoever, you need to work with it. And what I was more concerned about, given that I represented a good number of construction contractors, was during the referendum to make very sure that I was not voting on any of the contracts to award or any payouts to any of my direct contracts, or to any of my direct clients. I didn't, none of my clients were awarded any work on the job, on the referendum project, so it didn't come up, but I was very mindful of that. But I didn't want to just ask, just to have that out there, because a lot of our clients are public record, you registered agent for them, so.
More than likely, if there's a conflict at all, it would be a common law conflict that could be resolved through disclosure and recusal.
Right.
If the economic interest becomes more direct, then we'd have to take a close look at whether there's a statutory conflict. And, then the resolution, we have to get rid of the conflict, or you'd have to get off the board.
Right.
And we had a situation where a board member a number of years ago was doing some work for the school district that passed the threshold, that board member chose to continue to do the work for the school district and got off the board. But it was disclosed and dealt with.
Good. You done with your part, Brian? Good job, Brian.
I'm sorry, can I ask real quickly, I have another, you mentioned no school resource for political activities. Is that the resource meaning like funds or facilities, and what constitutes as political activity?
Yeah, so the law defined, there's a myriad of what's a prohibited political activity, so it would include working for a candidate, advocate. I don't have the list memorized, but it's pretty much everything you can think of related to politics. As far as resources go, it would be dollars. It may go, it does not define resources completely, so it may go beyond that as well if you're utilizing maybe even the email address, although that would be very de minimis, I would say. But I would suggest that if you are dealing with your campaign, you should be divorced completely from utilizing any sort of school district resource, be it paper, be it pencils, be it your email address.
Right. I guess for me, I mean, we've had like politicians come to our schools, so that would be, that wouldn't
totally
consider
correct.
Political activity. It
No,
was just, okay.
no, that's speaking to the students and such, and
Yeah,
We attempted
well, we had one, well, go ahead. Go ahead, you might know the situation better. Go ahead.
One where, a person came in and they were invited in by a teacher, and they used some of the pictures they took on their campaign website, and somebody asked them to take down that information right away, and then another person came in, and it was more a school event versus, and they came in, and I don't know if it was used on their website or not, but it was definitely used in the school, which was fine.
Well, I mean, one of this, actually, this later example, I think it was I believe the politician came in to talk about a bill that he wanted to promote as law, so, or to promote to be a law. So would that be considered a political activity because it is?
But it was relevant to the students' project.
So I guess I guess it's like it's up to.
I'm talking about when a board member is involved.
Oh, it's a board member.
Yes, where it's a board member, correct.
The question is a good one, though, because politicians like to use schools and kids to promote an agenda. And, I think part of what, these requests would come in, and I'm sure Melissa would be looking at, what's the primary motivation or purpose. And, I think most schools would tend to want to stay away from where it's a political purpose. I'm promoting a particular bill, I'm promoting my candidacy, those types of appearances versus, I think what Jess was, where it has a school benefit, a school purpose that really outweighs, is bigger than the political purpose that might be served for the candidate. I mean, I think there's, that you would be more inclined to grant that and less inclined to grant the, what's a staged political event. But we find that, it rarely results in serious consequences in terms of a legal nature, but it generates controversy in the community. And the community is looking at you as a board or Melissa as superintendent and saying, why are you assisting in promoting this political viewpoint? That's where we really need to be, I think, careful and take a good hard look.
And I think that's right. It's the image that we promote, right. Because, for example, in the school I teach in, we had a congressman come in, and it was for a Veterans Day celebration, and he made no speech, or he just greeted everybody and said hello, and we were, it was a patriotic. We had Sanchez's family, the war hero who our school is named after, come in, and it was quite an enjoyable event, but there was no politics whatsoever discussed by any means at all. It was, hi, I'm here, I'm your congressman, and we went back to the classroom, what is a congressman, that kind of thing. And it was fantastic, I thought.
There, the educational purpose far outweighs any political implications.
And that's where I'd like to keep it here in our district too, of, we're not going to talk about, I didn't know we talked about a bill, but I would just much rather have it be, unless that's in the classroom, but much rather have it be, it's Veterans Day, it's Flag Day, it's MLK or whatever.
I don't remember whether press has a model policy on that, and I certainly don't remember whether 41 has something specific, but that can be an appropriate local policy direction that you as a board develops.
I believe our policy, sorry, not to interrupt, sorry. But I believe our policy basically says what you said, that if there's an educational purpose, and then kind of like, the educational purpose outweighs the political gain, I guess. But I I guess then it's a little bit up to interpretation.
Yeah, I mean, you can't go down to the millimeters
No,
on
that's-
that
I understand,
decision-making,
so-
but I mean, you can give the broad strokes guidance to Melissa and the staff to make those judgments.
And
It-
I'm just,
Sure.
I don't want to give anyone the wrong impression either that it is part of our policy to provide civics lessons to students. And so, and in that event in particular, it was a discussion of how I became a congressperson, how I've worked to pass the bill. So it was more about the how and the process, not a promotion of a particular bill. But it was related to the students' project. So I think in that, I want to be clear that in that situation, there wasn't
That's
a
the
promotion
context
of the
that-
bill. It was
that's-
educational
Yeah.
material.
It never came to the board, so just, I mean.
Well, but that
I've
wouldn't
done
need
it
to.
afterwards.
That's,
No.
that wasn't
No,
us.
but I was, it didn't come to the board, you know, and I just,
This is where the
I wasn't-
administration takes your guidance through policy
Right.
Right.
and administers it. And, if the decision turns out to not be a good one, it'll come to your level and, you'll
look at the
have.
policy.
yeah,
Can
look
I
at
ask
the policy, you'll
a
have that
related
discussion.
question? So you had mentioned if one of us is a candidate, then it's subject to these rules, or if we're working on behalf of another candidate as a volunteer?
Yeah, so let me be very clear on that. So you are allowed, you as board members are freely allowed to engage in your own political activities, other campaigns, et cetera. Those are technically under the statute, and the statute gets a little confusing with its language. It calls that a prohibited political activity, but you only violate the statute in certain circumstances as a board member. And the only way you violate the statute is if you utilize school district resources for those prohibited political activities. So if you are working on a presidential campaign a few years from now, you decide to use school district resources to assist that presidential campaign, that's a violation. The second way a board member can violate that act is if you require an employee and you say, as part of your employment, hey, I'm going to give you a promotion if you help me on my board election. That is a violation as well. For employees, they cannot be working on prohibited political activities during the workday. Now, with all of that said, if a teacher says, I want to work with Jason's board, I really believe in Jason, I'm going to support him, I'm a resident, they can do that of their free volition, but they have to do it after school hours, and make that very clear. Okay?
And it does extend to facilities in those circumstances, like setting up a phone bank at the district. That's using...
That's probably not a good idea.
Dave would notice or something.
Right. But that's been the subject, of a lawsuit.
So to that end, I'll just ask a question. So what are facilities? They're not facilities that the school district leases or rents on a as-needed basis. It would be school-owned, full-time operating.
Correct. Correct.
I heard the answer. We use different facilities outside the district for different things, so.
So you wouldn't want to rent a facility and use it for a political activity, though?
Well, I'm saying, like, if the district is something in one place and you did at a political event, completely unrelated, separate time, months later, that's not a big deal.
If it's a separate facility and you're not running it through the school district?
I don't think I completely followed that.
I'm not sure I got
If
your...
the district were to rent out the space for a program.
Okay.
Oh, I see.
And then you someday use that same...
And then you
space?
said they use
That's
that
not a big
space.
No.
Even an
Okay,
argument
good.
can be made that even if you were to rent under your facility use policy, facilities to engage in a political activity outside of the school day, I mean, that's a possibly permitted, whether it's wise to do that.
That sounds like a great
Is
idea.
another story. But we can't, under a facility use policy, we can't really pick and choose on political viewpoints either, so.
Right.
That's where the First Amendment kicks in.
Okay.
As is typically the case, the last presenter
Always gets
the short
crunched for
script on
time.
the
We'll do a really brief overview. So my name is Dana Crumley. I've been working with Forensic for 18 years. Prior to that, I was a public school teacher for 8 years. So long history in public education. I work with the district on special ed and student matters. Obviously, this involves student discipline, residency and homeless matters, special education matters, matters under Section 504, which is a related disability statute to IDEA, actually the precursor to IDEA, and, student discipline matters that range from bullying, harassment, sometimes Title IX matters. So that's a large variety of matters that touch students. Since I have such a short time, I think the most important thing from the board perspective when considering student matters, these are closed session matters and confidentiality is the utmost. We're talking about very sensitive situations with students who may be people that you know or maybe people that you don't know. And I think the community's trust in the board is really dependent upon the board's ability and the district's ability to keep these matters confidential to the greatest extent possible. So we stress that with your teachers, we stress that with your administrators. It's very important to be circumspect and above board. I know that a lot of times things will come to the board, a student discipline matter will come to the board, a special ed matter will come to the board, and the board may have views and opinions. I'm not saying you should share your view and your opinion on the facts that are presented to you, but it's really important when we're considering these things to consider them fairly and going back to due process and making sure you're considering things that are in the record properly. So things that you may have heard from another parent or things that you've experienced with a child necessarily should not be brought to the table when we're thinking about a disciplinary consequence for a child or a special education placement for a child, or if there's a litigation in special education. We really have to stick to sort of the facts that are in the record. And, I encourage board members, if they have questions, if they have legal questions, to make sure that those come to us. Our job is really to, again, be the board's attorney and work with the administrators to make sure that their decisions are, number one, fair, that they comply with the law, and that they are student-centered. Because even when you have disputes over student matters, this is not like, it is not like you're never going to see this person again. These kids are going to be in school with you for 9 years. You have to maintain relationships with the families in your community. There are times you have to agree to disagree respectfully, but that relationship has to move on in a positive way for the benefit of the students in your community. And that's something that we really try to stress and focus on when we're working with administrators. So I'd be happy to answer any of your questions. I don't want to take up too much of your time and just go on to things that you might not have questions about, but we're always here to provide you with the answers to the questions that you have.
I would just like to expand a bit on Dana's comments on confidentiality to, she's emphasized students, but the same principles to a great degree apply to employee matters, collective bargaining matters, litigation matters, communications that are privileged or private between your attorneys and the school board. Besides, in many cases, like confidentiality with respect to students and employees, which there are actual violations of law in disclosure of confidential information. When we get into the area of litigation or collective bargaining agreement matters or negotiations to acquire a parcel of property, in those areas, the disclosure of confidential information can really put forward a leg down in achieving successful negotiations, in achieving an appropriate outcome of litigation or almost any other matter that we're trying to reach a certain goal. The breach of confidentiality compromises the ability of the board to get to the place that we'd like to be. Just as a practical matter. It also undermines trust.
Do you have a question?
I do. When you were talking about student confidentiality and all that, I just want to, and one thing came to my mind, which is accountability, where I think we've had incidences where I think it was hard for the board, at least for me as a board member, to see kind of the progress or and I'm trying to think of a good example, but maybe, for instance, we were looking to see any improvement in certain areas, or but because the numbers of students were so low that we couldn't get the information, I think, to understand how things are progressing. So I guess maybe my question is, at what point is there a number that it becomes okay then to open up to the information? Or
Yeah, there really isn't a bright line number or test, and that's something that, as the board is seeking information, we talk to the administration and see if there is where we might need to draw the line, or relative safely draw the line, but also to look at, is there another format or reporting method that the board can get the information that it wants without compromising confidentiality.
Okay. So, I have some questions that, well, first of all, thank you on the presentation, on the nuts and bolts, on each of the areas that you focused on. I have some questions having to do with efficiency of our meetings, to make them as productive as they can, not to have them extend beyond a time frame that's really productive to good rational thought. So I want to ask a couple of questions, and other board members perhaps have questions related to this that are in the area of efficiency and the use of some process. We use a modified Robert's Rules of Order, but I'd like you to sort of think about these items in that context. One having to do with the advisability, the benefits of agreeing to a set of rules that allow board members to speak to topics, but not to endlessly speak to topics, so that you can speak to topics a couple of times, but there isn't a continuous kind of return on the same topic to the same board member. That's number one. Related to that, some direction and guidance in terms of timeframes for discussions, given that it is a business meeting, given that oftentimes we've addressed these issues on more than one occasion, the advisability of timeframes, and agreeing as a norm, really, that we will agree to hold to that. So I want you to sort of offer some thoughts on that. And then a third thing, not in terms of an opinion that a board member has and communicates, but where there might be some debate or confusion around statements that are given as fact, or that there's something that's on the record and perhaps we don't all agree that it is in fact a fact, right? There should be a record of this. A process, for lack of a better term, of fact-checking it right then and there, a way to kind of get at it. Do you turn to your administrators and ask your administrators for questions to respond to something? Is that a good way to do that? And this is different than just, my feelings are that something is A, B, and C, certainly free to express it, but if something is stated as a fact that something occurred or did not occur, something is or isn't, and we're not in agreement with that, or we question that, the appropriate way to get an answer to it, is it to turn to the superintendent and say, or turn to one of the administrators who would know is it simple as that, and that should be the process that is used? Anyway, so these are efficiency questions. I'm trying to look for ways to help us be more efficient. Yeah.
I think your first question was just about, limiting comments. And I think there's a balance. I think you definitely want everyone to have the opportunity to say what they're going to say. But at the same time, you don't want to discuss things ad nauseum and be circular, because I think that does undermine the trust that the community has for the board in being able to make decisions effectively. And, I think there's a time limit for all decisions, and I think if you go into a discussion with a goal for that discussion, like, we're going to have this discussion, and, I used to always kind of say, it's even on hard things, it should be drip, drip, drop.
Should be what?
Drip, drip, drop.
Drip,
It's my
drip.
little weird thing that I have in my mind. Like, you might discuss it at one board meeting, and have an initial discussion. You might discuss it if it's a hard topic, and not everything requires this much of attention. But if it's something that the community is particularly interested, you might discuss it again. But then at the third board meeting, you've aired it out. You're going to make a decision. And that would be a complex topic. I think on more simple topics, you need to go into the discussion with what is the end goal of this discussion. We're going to make a decision. Our decision might be 7-0. It might be 5-2. It might be 3-4. It is what it is. And you make the decision and you move on. You can't really filibuster. I mean, once everybody's had their piece and they've sort of said what their opinion is, if it's just a matter of like someone trying to persuade the other person, I don't know how many of you are married, but there's a limited return to that. You even try to do it with your spouse.
Yeah.
Like when you just try to
You know my
convince your
spouse.
spouse of like, this is the way we're going to do it. And at some point you have to just accept that you're having a disagreement on something, make a determination, be the winner or the loser, and move on. And so I do think, not to be too pat about it, but it is important to have a goal and to really look at with the superintendent, how long do you think this discussion is going to take? And plan the agenda accordingly. Don't put too much on the agenda. If you know if it's going to be an important topic, think about a special meeting so that you can discuss that topic without a lot of other business matters sort of weighing you down.
All right.
I don't know if that's helpful.
No, it is.
Can I ask a question, because it's kind of follow-up to what you said about the drip, drip, drop? That is going to be maybe used quite often. It's a very good visual. Then what about, I guess my question is, I've been on the board for 2 years, so kind of had things running a certain way, and then I guess my question is, we've had, in the previous 2 years, from what I remember, was that we've always had discussions. For the most, I don't know if there are other sections, but from what I can remember, we always have discussions, and then at the following board meeting, we would action on it. So there's that drip, drop. And unless it's then, of course, like you said, if there's some harder topics, we definitely had drip, 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 drop.
much drip,
But
not enough drop.
But in terms of, I guess, maybe going back to the law or policy or best practice of, action, just action and no discussion, or even discussion on a day. I guess maybe going back to just action without discussion and then action on that day, or just action. Like what are some maybe rules or best practice or laws around policy? I don't know. Like everything under the sun. Like that's a best practice, I guess.
You can't take action on something that you haven't, that's not on the agenda and there hasn't been discussion on, right? So you don't want to just take action on things willy-nilly. But I think it depends on the topic. I'll give you an example. We once had this is a shameful story from my years as a board member, we had this huge discussion about terrazzo, which is a floor tile.
Yes.
It's a very expensive floor tile, which needed to be put in a building that's on the National Landmark Historic Places, Crow Island School. And we literally, were so in opposite direction about the terrazzo. And it went on and on and on. And that would be an example of, that is not a good thing to just talk about endlessly. You know what I mean? And I think at some point, someone finally just said, I am not going to talk about this anymore. It was like a 3-4 vote. It went with the 4. We got the terrazzo. and it was over. And I do think that you have to just, it's going to be different for every topic, right? You need to use the superintendent and the administrators and, your judgment as board members to determine what topics require, you have to set priorities. You have to triage. You can't have endless discussions about floor tile.
No.
But isn't there,
Go ahead.
isn't there like a proper give and take? I mean, I think I know we're trying to limit the time we spend here in the board meeting because I've got home at late at night, or early in the morning rather. But I think it's important to also give everybody an opportunity to talk and try to complete with that board norm of not being interrupted and completing a conversation, because I know I've been here for 2 years, like Linda and Bob, and, I've had moments where through our board discussion, we have either changed each other's minds or garnered new information about a certain topic, but that was topic that maybe was talked in a board committee meeting or something like that, but hadn't been brought to the full board and was, enlightening. And the way I got that information wasn't by having a quick 3 to 5 minute conversation about the topic. It was actually grinding through a board discussion that was either more complicated than we thought, or less, or just all sorts of things happened. It wasn't just one person stating for 2 minutes what they thought without discussion. It was a true board discussion. And I would hate that shouldn't be limited, correct?
Well, I don't think it should be limited, but there is a point where you repeat yourself.
Sure.
So when I was a very young attorney, and I don't remember if I was with Todd or someone else, there's a point where you've made your point and you need to stop talking, or the judge doesn't like you anymore. And I think in a public meeting where everybody is here, observing you, that's something that maybe as, lay people, you're not attorneys, but also teachers, right? There's teachers when they're in the classroom, and I taught 8th grade for a long time, there was a point where you have to take a different approach, or you have to stop and turn direction, or the kids stop listening to you. And that is a very important point to be mindful about if you're trying to make a decision, because then if you get to that point and you push beyond it, you're not moving the discussion forward, the discussion is stagnating. So it takes practice. It's not something that's going to be, like, there's growing pains. Every time there's an election, people need to, get to know each other and establish trust and develop a rapport, and that can be, challenging at times and difficult, but it's possible. And I think, your board norms are there for you to help you, like, has this point been raised? Have we covered this? Or if it is something really new, then definitely you do want to have that new idea be brought forth.
And, the problem that is what's being presented here is one that is certainly not unique to 41. I mean, we see it across the broad spectrum of our clients. And most of our boards do not have, many boards have norms which begin to address some of the courtesies of communication and not interrupting and those kinds of things. What we don't see are boards that have established procedures that address typically how much time might be afforded for a topic, how much time might be afforded a board member to speak to a topic, how much time or what process would there be to address the concern that Bruce just raised, is where an individual needs and should have more time to address or a topic, ask questions, explore, and the board should have more time than maybe what was allocated. What I would suggest is that you begin to look at development, a supplement really to the norms that address some of these procedural questions, so that you've got a set of, I'm going to say rules, but it's a combination of rules and guidelines. And I would also, just to come back to Bob's first comment about Robert's rules, is that Robert's rules really aren't designed for school boards. Robert's rules is, depending what edition you get, it's this thick. And it was designed to address larger group discussions. You really can take probably 4 or 5 rules out of Robert's rules and develop those as your own rules. The District 41 rules, whatever you want to call them. We've done some work in the office on this, and I have been chided as Todd's rules.
We got off-the-shelf Todd rules that you can...
And so the point is that you can develop District 41 board rules and guidelines in addition to your norms as to how you're going to interact with each other, how are you going to structure your meetings, how are you going to make sure that the concern that Bruce is raising is adequately provided for, and yet still have an efficient meeting.
And it's not...
I think our suggestion would be try to begin to look at these things and look at it in terms of board procedures, a very much pared down set of rules. Here's how we do it. This is what kind of motions can be made. Here's what it takes, a second. Reconsideration. How are we going to handle that? And identify your own rule on that. Don't leave it to the vagaries of Robert's rules.
And can I ask a follow-up to that then? If we find ourselves in a circular or repetitive discussion, what's the most respectful recommended way to call attention, our collective attention to that and move forward? Is it point of order or some other... What's in Todd's rules?
It would be, first the chair would make an effort to bring things back to perhaps where they should be. And if that's not successful, a motion which would take priority could be made and passed to limit discussion or to extend more time for discussion. If let's say that Bruce is sensing, I need to ask more questions. I need more than the couple of minutes that have been allocated to me. And Bob says, sorry, Bruce, this is our guideline. I'm, as the chair, I'm limiting you to your 2 or 3 minutes. A motion could be made to overrule the ruling of the chair. And thus it would be that would be one of the allowed motions.
Got it.
But a board member needs to also feel like they've had their chance to speak.
Right.
And you can't cut them off. Let's say we made a rule that it's 3 minutes, and I usually don't speak for more than, I try not to speak for more than that amount of time. But one time, when we were starting out here, I got interrupted 18 times. And I never was able to speak more than 45 seconds. And I felt very bullied, and then people were pulling Robert's rules, got to do this, etc. And first thing I looked up on YouTube when I looked up, because I was pretty incensed that night, I looked up on Robert's rules is, don't use Robert's rules as a sledgehammer or a weapon.
I'm suggesting to you, don't use Robert's rules.
And I would suggest that we shouldn't use Robert's rules in that format and that way until we've had training on it, which I really don't want to go to. But until we know what we're doing with that, then everybody's like, well, your point of order. I'm like, I don't know what a point of order is.
That's why we're
Do I need to
suggesting...
be quiet? Just tell me nicely.
That's why we're
following our board norms.
Develop your board norms, which I think you have. Develop some procedures and identify a handful of rules that are going to handle probably 99% of the issues you would take.
That doesn't mean if a board member, what I'm saying is, if a board member brings up something other board members don't really want out in the public or don't want to hear, but a board member's trying to be transparent, they can't be quieted by the fellow board members.
Well, I think that, again, it's not about being quieted, it's about, is it in furtherance of the discussion? There are other points of the meeting to bring up, some of the things that are, bothering you, but I do think that this is also something that maybe the board member that's having the issue maybe needs to talk to the board president beforehand to talk about the agenda and what needs to be raised, because there has to be a consensus about what you're going to talk about and whether it's really necessary business. So it is, I think, a school board, sometimes people think of the school board as like we're all representatives. You're really not that. It's not a good comparison. It really is a committee of people that are working together. So it's not like what you see on TV where somebody speaks out on one side of the issue and then somebody speaks out on the other. You're going to raise differing views, but it really is more like committee work. So if you think about things that you've worked with in your jobs or, in volunteer work, and when you've worked on, committees and you've had to make recommendations and determine courses of action jointly, that's what, the goal should be. And that means that you speak, but, I do think that it's, you have to sort of start off with speaking for 3 or 4 minutes and give someone else a turn.
Sure.
And so it should be, turn taking and not just 15 minutes of one person just because they have so much to get out, because then that's more fosters like one person talking and not discussion. So you want to think about discussion.
I think you could develop a set of guidelines and rules that would accommodate, or go a long way toward accommodating the concern that Bruce has.
Well,
and the concerns that you're raising about in terms of efficiency.
Yeah, and I've actually taken some notes about that. I mean, I would be very interested in my board colleagues taking a look at or considering procedures or rules for functioning. And you made a really good distinction between the norms and then what's really not done. So we can't just take this off the shelf and use it in a way that's effective. But there's still going to have to be some rules, some procedural practices, human beings being what they are, that we're going to need these rules. And certainly if other board members would be interested in seeing what that might look like, and not to poke fun, but if there's something that you've used, whether you've called it Todd's rules or something else, as a starting point for the board to look at, I, for one, would be interested in seeing what those are, because then we don't have to have a situation where Bruce or anybody else gets offended by a decision that the chair makes, for example, and at the same time the chair doesn't have to be frustrated if he thinks the conversation is not germane, or if we are going in a circular motion. I think it would be great if we could collectively come up with those kinds of procedures. I don't know.
I think they're there.
I don't think they're there.
I think that...
I think we have the norms, but we don't have procedures.
When did I get frustrated? When you and Kurt were, interrupting each other consistently and constantly. I mean, to bring it back to that, but, I generally respected a person's ability to talk, say what they wanted to say, and then move on. But I think that, in the interest of transparency, I think we do need to hear from each board member. And for example, when I was interrupted at the beginning of the summer and became very frustrated, I noticed that I never got to speak more than 45 seconds at a time. I kept getting interrupted, and it was very, very frustrating. I called the person who was interrupting me and explained to them that you cannot limit a board member's ability to say what they think. And a lot of that had to do with the past history of the school board that had occurred before, and hashing through that to get to a point. Well, I couldn't get to a point. I could have gotten to a point in 2 minutes or less, but I kept getting interrupted, and my point was lost in the interruptions.
One of the things
that's what drove me crazy.
that the rules can address.
I hear that.
And I think that's something that we can talk about at a future date, and that we can come up with collectively to
I
address
think
all.
a good way to wrap this, just sitting and listening to all of it, is really the training that we have coming up, is really to talk about governance. What does it look like? What is that strategic role, and what is that strategic work? I believe some of this is going to come up in those discussions, because I think it's fair to say that, when you have meetings that go this long, twice a month, consistently, and with all the special meetings that weren't necessarily connected to the superintendent search, efficiency is a challenge. So I think, what I'm hearing from people is, it's time to turn a corner and kind of look at how we're operating, and I think that's going to come in some of the hours that we're doing next. because that'll really be connected to governance, and maybe part of the conversation that has been going on or been very time-consuming for the board is because it hasn't been at a governance level. So I think once we elevate the board's work and get it to a governance level and take some of that operational stuff out of the conversation, it's going to give this board back time. I'm hoping that, the board recognizes that when it works strategically, it doesn't need to have meetings that go this long all the time.
That said, I have a lot more questions.
Go for it, Jess. Thank you for...
All right, I think one of the questions that came up in our last meeting is related to specific policies that we were looking at and had questions about. So Bob has addressed the attendance of people at other at board meetings. And I lost my place. There's one that is in regards to the board president responding on behalf of the board to media is what is in our policy. But what is our practice is that if the community emails every member of the board, then the board president responds on behalf of the board to that inquiry. And that's our practice, but that wasn't reflected in our policy. And I'm totally lost in my notes which policy that is, but I think it's 2.140 maybe? Yeah. Yes. So the individual board member will not reply to an email on behalf of the entire board is what is stated in that policy. But then in an earlier policy that specifies the president's duties, we wanted to add to that the president, where it says that they can respond to the media on behalf of the board, that they also can respond to the community on behalf of the board to reflect our practice of what happens when the entire board is media. Thoughts?
I think we follow it.
Is your
What's your
question,
what's your question?
Is that proper?
Yeah, it's not our policy now, and I think there was some debate at the last meeting as to whether or not the board president really has that authority to reply on behalf of the board to those kinds of inquiries.
If you give the board president the authority to do that, that's within your discretion to do.
Right, it doesn't have to be in the policy.
Oh.
Necessarily. If you all decide, we got an email, so there's an initial email. There's an initial email, like someone should send, just as a practical matter, right?
Right.
There should be, we received your email.
Which we have an automated reply that does
Right,
it.
okay, so that's that. And then there should be, if it requires response from the board, then there should be discussion, consensus on the response, and then someone delivers the response back. And if the rest of you, in coming to consensus, then have a response, then the president would send it.
Jess, go ahead. I think it was Jess. I don't know who.
Well, but right, but that's what I'm saying, like the board, you're talking about just responding to emails.
So an email comes in, it goes to every board member. Oops, I'm sorry, and let's say it's stated as a question. Someone's looking for a response. It goes to all the board members.
Okay.
All right. We don't have a policy that says what happens that authorizes someone or others to respond, but the practice has been, and it's been faithfully honored, that the board president will send a response on behalf of the board. Now, this is, you get the email tomorrow morning. The idea is to try to respond within 48 hours. We're not going to meet for 2 weeks. So
basically, I think if it's just a perfunctory question, and I never answered those emails. Those emails that come, they should go to the superintendent. The day-to-day business of the district, if it's, the board president should not be answering things.
Well, no, but maybe they're relevant to an action the board took. It's directed at the
I would
board.
look at, you act on behalf of the board. And you could act the board, in consent, following board majority. And if the board's taking action as a majority one direction, that would be really the only response that...
Is to say what the board did.
Right, I mean, to speak in your individual opinion on behalf of the board, I think is something completely different. But to represent what has taken place is another matter.
So that's been the practice, but we don't have a policy that is parallel to the board president response to media requests. We don't have something parallel that says the board president responds to community requests that go to all board members in the most literal way. And so we thought, Jess and I are on the policy committee, well, let's have the board kind of look at squaring that, actually.
That's something that the board could do if the board wishes to adopt that policy. You've got discretion to do that.
I would also be specific, though, on what you're responding to.
With the kinds of responses.
I just think you need to be careful on that. And as Dana was suggesting for fundry stuff, it's not something really the board president should be acting on. Things that are opinion-oriented, you need to be careful about that. If it's the board acted on X, and this is what it means, that seems to make some sense to me.
But the superintendent would also have the ability.
And the superintendent would have.
Well, I'm thinking about situations where if there was an ISBA recommendation last year or 2 years ago or something, and the board would receive several emails regarding, this is our position on this is our position on that, and there's, the proper response could be, the board will be considering this and taking action on X day.
Right.
Yes, yes.
They should be pretty vanilla responses.
Yeah.
If it's beyond that,
that's
you probably need to talk to the board about it
Sure.
in a meeting.
I agree.
Yeah, and I think that was part of why became a discussion, because the actual language is serve as the board's official spokesperson to the media, period. And what was added is or community, then it really broadens, I think, what that means. And I feel like as a policy, I think you're speaking to that basically, is that it depends on the situation, and I don't know if if it makes sense to kind of box ourselves into something, or community. It seems very vague to me. And I feel like and it becomes like, well, what is the or community? Does that mean like when you're going to a grocery store, like I can't talk to people, so that discussion came about. So I guess at least for me, it was how we work in practice, which hasn't been an issue. I guess I'm not sure, like, the reasoning for the ad.
And I don't know that,
thing, so.
and I think Linda stated that appropriately. What I think I heard you said, if we have this practice, it isn't really necessary to then also have a policy that reflects the practice. Jess and I, as members of the policy committee, thought we should bring it to the board to consider, to try to create some coherency. But maybe, and Brian, you're saying the language you would use in that policy would have to be appropriately crafted, which might, as Linda notes, make it all but moot, like when you could actually reply, or maybe it would be really hard to do that. So we could just abide by the practice and not add any policy language.
I'm sorry, Bob, but the practice is also not supported by policy. Policy actually says do the opposite, that you can't do it at all on behalf of the board.
So
you're saying it actually doesn't. Good point. I guess that's a good point, Jess.
It's many presidents long of a practice.
Yeah, that's a good point.
It's not that Bob's gone rogue or...
If there's a significant media event, and you need someone to speak for the board, usually that's the superintendent or the board president, that would be completely appropriate. I think it's your level of consternation on the issue. And if we feel, as you just suggested, I'm not suggesting Bob has been rogue, but if there's a concern about that, then maybe you need to, as Todd has suggested before, your policies you have the ability to craft the types of policies that fit board consensus.
Is this...
But if somebody, let's say a reporter were to ask the board president, obviously, on a vote or something, it's making news somehow, right? And another board member has a differing opinion on that. and that reporter comes to, another board member for that opinion, that, just because he's the spokesperson doesn't mean another board member couldn't make a comment that might be different than what Bob is saying, correct?
I mean, I think it's really difficult to speak in a vacuum. You need, I'm sorry to be very much a lawyer here, but I would need the specific facts on it. But as your code of conduct says, no board member is to act alone, right?
Right.
And so if there has been a certain action and the board has decided on something, be it a 4-3 vote, that's the board's position on the matter. Now, there may be situations where it is appropriate for a board member to say, yeah, that's how the board voted, but my opinion is X.
That's what I'm talking about.
But I need to know all the facts in the situation.
I mean, let's say, he says black, I say white, the vote's 4-3, and, he says, well, we did this because, and then they come to me and ask, and I say, well, the vote was 4-3. I obviously honor the vote of the board as a whole because we act as one body, but my opinion is XYZ. That's okay, right?
That was technically okay, yeah.
You heard that word, right?
You say technically.
Yeah, I'm sorry.
He likes that word.
I think the issue is that if there's too much, I always talk about this with staff when we're having meetings with parents, and it's really important, and, different staff members who have different fields of expertise often have very different opinions. A social worker might come in and say X, and the teacher might say Y, and they're all valid opinions. And I'm looking at Laurel because she understands this. But if you have too much dissent, if you can't come to some consensus, it really undermines for the parent your expertise and what you're recommending and what the course of action is. And I think you always have to consider that. You hate to go to a doctor or a team of doctors at a teaching hospital and have them say in front of you, I think that guy doesn't know what he's talking about. I want to, crack your chest and do this. And the other guy says, no, he absolutely... You leave there just feeling very confused and very... So I think it's important in all your conversations to, you can respectfully disagree and to make sure that you don't misrepresent anything. You can certainly state your opinions, but to misrepresent some of the underlying information would be wrong. It would be harmful to the whole board, not just to the side that you might not be on, but to all of you. And all of your, standing.
And not just the board, but to the district
Right.
as a whole and the perception of the district.
Right.
And can I ask Bob you a question? And this will be, I think will be a healing process. So this just occurred to me because I didn't quite understand the add to the language. But is it about when a couple of things that happened, maybe kind of when the board turned over, I think maybe regarding, was it like, maybe either like a letter to the teachers or like you as a board member representing or board president representing, I think it was like a meeting or something, and then that it has nothing to do with this, like this when, okay.
No, it
I just want to...
No, it didn't.
I didn't know if that was like, because then I had a lot of opinions about it, like you felt like we needed to, okay.
Yeah, I don't know that this is an issue that we can kind of resolve and help you come to a conclusion on tonight. I think we've heard some competing interests, important interests, that if we were to talk some more with Melissa or the policy committee, we could give you some thoughts that might be helpful in accommodating, again, some of the different things that have been said here. The point, I think the takeaway is that the board has wide discretion to formulate how it wishes to act, and I think a little bit more discussion, we probably could suggest some ideas that could be used by the policy committee, by Melissa, to develop a recommendation for the whole board.
Great. Jess, did you have additional questions?
They're related to that, so I think we can just put 508 as part of that. No.
Are there other board members that have questions that didn't get answered or topics that didn't get addressed that... Linda, I didn't see you back up.
This is a lawyerly question, I think. We,
Starts with technical.
So kind of offshooting policy, we have a policy that was regarding sabbatical change, and before it had referred to school code, and now it's being changed to our teacher's contract. And I think Todd, you maybe could, you know our district well and know maybe what the practice, is this like is it, I don't know if you have any, but is it like, it should have always deferred to teacher's contract, or should basically school code always trumps anyway, but we're just defining it, fine-tuning the policy? Do you know what I mean? Like, that, I guess I'm just, that change, I'm not sure I understand the change.
The school code identifies some parameters to sabbaticals, and we can't go too much broader, or I should say more restrictive than what the school code specifies. But a collective bargaining agreement could expand the opportunities for sabbatical if you wished. A policy could do that too. But the Educational Labor Relations Act says that a collective bargaining agreement really can't be take away rights that are granted by the school code. So, in a sense, you look to the school code first, and then we do have some discretion that we can exercise through a policy, through individual action, or through the collective bargaining agreement to fine-tune the sabbatical process, if you wish.
So if our policy refers to the teacher's contract, then are we then being more, I guess I'm, is it like, does it matter?
If the policy
or like,
defers
does it
to the
more
collective bargaining agreement, you're simply, there's consistency between the policy and the collective bargaining agreement. And if the two conflict, there's a fairly good chance that the collective bargaining agreement will trump the policy, unless the collective bargaining provision takes away or unduly restricts a right that's in the school code.
Good question. Thank you. Did you have anything else? Yes, no? We good? Yeah, yes, of course. Then you've given us more than our money's worth. And we thank you for doing that. Thank you very much, all three of you, Brian, Dana, and Todd. We really appreciate your being here and your service to the district.
As a side note, I know we have some other items. Can we push those back on the agenda and deal with the closed session items since Todd is here?
Well, we do have on the agenda that we will go into closed session.
Right. Everything says Todd's already here.
Yes. Right, just on this issue.
Right, I was saying, can we move it up since you're already here?
Oh, you're saying can we move the closed session up because Todd is here as opposed to...
Right.
Yes.
They're not heavy-duty items.
They're not, I don't think...
I say tragedy play.
I don't think, Todd, if you don't mind, I don't think these are...
It's whatever you're...
They should take a lot of time if you're willing to stick around. Maybe Brian and Dana can keep you company. No, Brian's hitting the road, I can see that. Brian, thank you very much. Thank you. Dana, thank you so much.
You're welcome.
Thank you. Really appreciate it. Okay.
Excuse me, Mrs. D'Ambrosio, I'm going to have to ask that you sit up when you talk. I can't hear you and I can't see you.
Okay.
Thank you. I just don't want to miss anything else.
Okay. The next item on the agenda are board reports. Are there any reports from board members?
I don't have a formal board report, but I know that all the PTAs are setting schedules and looking for committee chairs and asking D41 committee members or community members to join the PTA. And anyone can join that's in the District 41 community. It doesn't have to be a parent. And then also for the fellow board members, I did some light summer reading from our board library. So the Building Great School Board Superintendent Teams book, I will be returning to that library, but I recommend that. If anybody has any questions about it, I'm happy to answer. And I'm halfway through, this is kind of chewy, the student voice, which leads me to a thank you for the League of Women Voters for hosting the Sip with Soups with the superintendents from District 41, 89, and 87. And the superintendents there shared that 87 has had a student on their school board. This is their second year that they're entering with that, and District 89 is starting their first year with that. And this book talks about that, and so maybe that's an opportunity for District 41 to follow that practice in giving students more of a voice at the table. So I wanted to thank the League of Women Voters for hosting that event. And I will return this soon because I got to get through it, but thank you.
Thank you, Jess. Anyone else? Thank you, board members. We have a discussion item, the intergovernmental agreement with the Glen Ellyn Park District involving Spalding. Melissa.
Right, I had shared this information with you in one of the regular updates. I'm going to ask Eric to give a quick update as to where we're at with that IGA.
Yeah, actually, Brian, who was just in front of you, helped us work through an agreement with the Park District. In summary, what it's going to do is really just memorialize some property rights between the Park District and the school district. We've already presented that draft agreement to the Park District. They had it reviewed by council. They didn't have any issues or concerns with it. So tonight is just a discussion to kind of update you on the process. It's really straightforward. The interest is just to make sure that there's memorialized written language that talks about how structures that are on district property that were erected by the Park District, and talks about basically a written agreement having the Park District admit that they did that and accept ownership and actually I think indemnity for insurance rights. Is how it's written into the agreement. So very straightforward.
Yes.
Happy to answer any questions. Intend to bring it to our next meeting for approval, and then it'll be sent to the village, or actually the Park District, so at their next meeting they can have it signed as well.
Board members, any questions for Eric? Okay, thank you. Thank you, Eric. The next item, we have action items, the consent agenda. Are there any items board members would like to be removed from the consent agenda to be considered separately?
I'd like to pull the board meeting minutes from August 12th.
Okay. The board member regular meeting minutes. Okay. Very good. Then may I have a motion to approve the consent agenda as amended, which includes the personnel report, which includes employment recommendations and resignations, the school district payment orders of August 6, 2019 through August 19, 2019, FOIA report dated August 6, 2019 through August 20th, 2019, the July financial reports, including monthly revenue, expenditure summary report, investment schedule, treasurer's report, summary of bills and payroll, vandalism report, and disposal of surplus property. Motion. Very good. Any discussion?
No.
No? Then roll call.
Mr. Estes?
Yes.
Mrs. Butterworth?
Yes.
Mrs. Hill?
Yes.
Mrs. D'Ambrosio?
Yes.
Mr. Lopa?
Yes.
Mr. Curry?
Yes.
Dr. Bruno?
Yes. I now need a motion to approve the board meeting regular minutes of August 12th, 2019 as presented.
Motion.
I need a second.
Second.
Discussion.
I did see Linda's proposed revisions to the board meeting minutes. I saw them this afternoon, late this afternoon. I remember the discussion. I didn't have a chance to go back and look at the video to So I'm not even prepared to really address it at this point. If everybody else wants to, I'm fine, it's fine.
Linda, did you want to take a minute to explain what part of the minutes you were raising the
It's
question
actually
about?
not related to that. It's just the, under presentation of superintendent entry plan, I didn't think it was, my recollection was that we had consented on waiting on the self-evaluation, and if you remember, we kind of went down around the table and decided that we were going to bundle the academic updates, but don't remember, I don't believe we went around and consented on the PD. And in here, I don't want to read the whole thing, it was a bit flipped. I think it said, sorry, I'm trying to find it. In here, it said it was basically that, like, it was consented to do the PD with Dr. Van Clay, and didn't mention this consenting on that delaying of the academic data. Sorry, no, I can't read this. Because if you remember, there were questions about, what exactly will we learn from Dr. Van Clay, and there was, here it is. Maybe in the middle of basically that paragraph, it says they concur to move forward with the FANZIC PD and CEC-PD, but would like to only schedule initial 6 hours. But because there were questions about it, so I'm not sure we actually agree on Dr. Van Clay. So anyway, I kind of just was trying to, I like to pull that and kind of maybe revisit this for approval for next time. Just to make sure we're getting this right.
So if it's just appropriate to go for board approval, I mean, if whatever happened at that meeting. Given I was traveling at that point, I wasn't physically present. I don't have my notes to look back on. That's why I said I want to go back and look at the video. Whatever happened.
I think, well, so it's my recollection that we in fact did provide support for doing the initial 6 hours, that there was additional hours that we would hold in abeyance. So some of the logistics in terms of when the meeting would occur would have to be determined, and we would expect to get a final agenda for the training. But it's certainly my recollection that the board did provide support and direction to schedule the training. There was not opposition to doing the training.
But I
don't see.
But there was like lingering question about what we're even doing, so what we're learning, so I don't.
I did provide the summary of the topics that he was going to cover. I think I sent that out the day after the meeting to the board.
Right.
Right.
Which is fine, I'm not saying, but I'm just saying, I mean, because this meeting minute, it's really about what happened at the meeting, that I want to make sure that we're, and that was part of the reason why I was, if you remember, I was sort of hesitant about approving the entry plan, because I thought there were still some, from the draft, there were discussions and decisions made, or I should say, things were consented and there were some open questions. So I was a little bit hesitant about that, approving the entry plan that night, and that was part of it, was that I didn't think we were nailing down the PD. So anyway, that's kind of where I was.
I agree with Linda.
Let me ask other board members whether they, from their time at this meeting, whether or not they actually provided consent to go ahead with the training but certainly subject to a timing, holding in abeyance the 4 hours plus the agenda items that we would want to know what the agenda items were. Linda, I'm sorry, Dr. Kay presented those afterwards. Or did you not provide consent to do it? I'd like to, I would need to find out. How people,
like when we had consensus, it would be, you're going down the line, not an actual roll call, but
right.
we're kind of going down the line, understanding where everybody is. And that's kind of, we did that for the academic data, which wasn't reflected here. So that's kind of what I was kind of, just generally, this entry plan. I do want to make sure we're...
Right. I guess I'd like to provide clarification though too, because the board technically doesn't have to approve the entry plan. It was a step that we were taking above and beyond. So we're kind of in the middle of whether these need consensus items, but, and we could go back and check the video, but the only outlying item from that was a request on the topics that were to be covered. Yeah. And so I didn't hear back from anybody after that, so we did move forward with scheduling. So if that's going to change, then...
What would change could conceivably be the topics, but it was not that we would be going ahead.
So doesn't this need board approval though? I mean, if we approve, for example, the Apple plan, we reversed our decision on that and had to take a formal vote on that. And this is a board decision. I think we need to remain consistent with that and go forward with taking a formal vote on this also.
Right. I think the difference is this was the recommendation that came out of the entry plan and it is in the budget versus... No, I wasn't there for the Apple discussion, but what I know, and Eric, jump in and correct me if I'm wrong, is that that was not an administrative recommendation. It was a recommendation made from the board table, which was why it needed to be done as a roll call vote. And correct me if I'm wrong on that, because it was before I came here.
No, that's correct.
Todd, were you going to say something?
Well, I think it required an approval of an expenditure that wasn't provided for in the budget. And your board policy prescribes that a roll call or a vote, approval of the board in advance is necessary if the topic isn't covered, if the item isn't covered in the agenda.
So the item is covered.
I don't know the circumstances.
Well, we approved the budget the day that we talked about Dr. Van Clay, so I don't know how then it can be accounted for in the budget. But I mean, I imagine there's a general board training budget, but I mean, that was the argument. I think that was the frustration with the Apple testing was that, well, there's a line item for the assessment or some sort of assessment, but we had on technicality then not do it, and so I'm just asking for consistency, and that was so I don't know.
So again, it's not my understanding that a roll call vote was needed in this regard. These are not similar situations. In addition, we did in fact approve an entry plan that included this professional development. The only thing that had to be followed up on were the logistics of that. And the superintendent provided those details afterwards. So I'm not quite understanding revisiting whether or not the board authorized, supported, directed the superintendent. I don't see the grounds for saying that. We can certainly go through the board and ask the board their recollection of what they were doing. I mean, two of you aren't sure that you did, or think maybe you didn't. But I'm not uncertain about that. It would be appropriate to ask other board members, would it not?
I really want to caution, going back to, and don't use this ever again to say you approved the entry plan, therefore you agree to all these things, because I certainly did not, when I approved the entry plan, commit to anything about the long-range plan, or how that might look like, or what any facilities plan is going to look like. And with regarding to this, I just, we did not go down, that's all I'm saying, so I don't want to repeat myself.
So the consensus we had for this last week is good enough for us to approve this, but the consensus that the former board had for apple testing wasn't good enough. I don't understand.
I'm just
the
looking for
difference.
consistency.
It seems like a
You
double
guys can say
standard.
one thing, but just be consistent.
No, it wasn't.
In a case of...
How is it not a double standard?
I think it's not a standard in that there's a specific set of rules regarding expenditures and how they're budgeted and their amounts. And the differentiation being, if there's something that is under a $10,000 threshold that is not included in the budget, the board can move forward with board consensus. If there's an unbudgeted item that's asked to be made an expenditure by the board in excess of $10,000, that is what requires the roll call vote. If the prior board did not go through the roll call vote, it was an expenditure directed by the board in excess of $10,000, and that's why we had to come back and address it again.
Let me suggest, the question before the board is, does the minutes accurately reflect what the board did? And I think if there's a question about whether more action is needed, that's a different question than whether the minutes reflect what the board did.
Right.
And if that's to be an agenda item at a future date, then, you would work that out as to whether that's an agenda item.
Well, I'm trying to get a sense of whether other board members share Linda's concern that the minutes aren't properly reflecting. I think they do, but I'm interested in hearing other board members. Can I?
I'll just chime
Jess?
in then. I think I was the one that asked for the outline, so I remember that. When I read this, it didn't strike me as being wrong the first time, but that's really where my memory ends. I did go back to my notes, and in my notes, it says we'd use the 6 to 7 hours with CPC, and then the board would decide how to use the remaining hours, and that we will get the availability and an outline. And so what I have in my notes concurs with what's in the minutes, but do I recall the conversation? Not clearly.
Ted?
That's pretty much how I remember it. We were discussing in terms of the first fixed set of topics, which would take 6 or 7 hours, and at that point we would revisit whether we wanted the extra hours and what sort of topics would we address in that time.
Okay. And Jason, Julie was not in attendance.
Yeah, and I already said I don't have my notes to look back on from that meeting, so without reviewing the video, I don't specifically recall, so I would take a step back on this one with that. It's just the question of amendment minutes didn't come till late this afternoon. I just didn't have an opportunity to review the video.
So we definitely have a difference here, and Jason isn't quite certain and would like a chance to revisit. So can we approve, Nancy, help me with this, but Todd, can we approve the rest of the minutes, but set aside this section of the minutes, presentation of superintendent entry plan, to allow the district to go
There was
back
also additional
and revisit?
issues that were being requested to be made as well.
Not in terms of approving the minutes, right?
I'm okay with it,
Hold on, Jason, I'm sorry, hold on, Ted, Jason.
I'm just saying, I know how it is when you're just kind of catching people on the spot, reading a huge paragraph, so should we just, for time's sake, table this and then come back? So that people have
That's what I want to do.
time to read this and, no.
Although, I'm fine with that in theory, but in reality, the PD is scheduled for this Thursday. So if there is a disagreement that we've agreed to move forward with the PD, then that means we would have to delay the PD that's Thursday, which might incur a fee because it's been scheduled and all that. So then that's yet another topic for discussion.
So we have this agreed on a couple $1,000s of expenditure, not really knowing what we were getting, basically, on that night, is what I'm trying to, because we didn't get the outline until the following day, so.
But no board members have, to my knowledge, have raised the question. And if you've not raised the question, you've had almost 2 weeks. I would think that silence is giving consent that, okay, we asked you to come up with an outline, come up with dates, you came up with one, I've looked at it, I don't have an issue with it. The superintendent would have every reason to believe that we should go ahead.
Well, I
don't understand.
I guess I feel like I did. I asked, and I think it was sent to all the board members to look at the III
You did.
list.
You did.
And because we're already committing a time and money to
that
conference and look at, because I wasn't sure.
Seems like
So that was the thing. I wasn't sure what people were looking for in terms of PD, and I didn't want to make that assumption. I thought about listening a couple and seeing that was what people were trying to get at. But I didn't want to assume, so I just gave you the link, and hopefully people looked through it. But, I mean, that night, though, we didn't even know when we were committing a couple $1,000 of taxpayer money, too. That's kind of, and then we kind of snowed that, and you said I didn't raise, nobody raised question. Well, I did.
You did. You raised the question about, as I understand, whether or not we could achieve the same ends by going to III, whether it would be an equivalent kind of professional development. And that question is separate from saying these items that the superintendent presented are problematic for me and I would not support doing those. We didn't do that. And that would have raised the red flag if you had done that.
I guess, I heard your concern in the email, and my thought was that it wasn't equivalent because the benefit of doing it in an open meeting is that we are discussing as a board, much like we did tonight, which you don't get at the III. And so I would say that in the prior meeting, we discussed it as an entry plan, even though I didn't know the exact topics. I knew kind of the overview, the intent and the goal, and the majority of it was so that we could go through a workshop model and be discussing as a board. And I did clarify some things with Dr. Kate today, just to confirm my understanding that it would be interactive, that it would be tailored to our district.
Let's give I want to give Dr. Kay a chance to respond. And then I have
Again, I think if we take this back to when we first started discussing entry plan, what I was asked to do was to come back to the board with options for PD as we're starting a new board superintendent relationship that were not through IASB, because the board's experience with those intense, bring somebody in workshop model had not been satisfactory, and the vast majority of the board members said they didn't want to repeat that. So I did investigation of other organizations that are able to provide the board with a similar set of tools and training to get a new board organized and up and running well, which is what I then brought back to the board. So that was discussed. So the first time we discussed the entry plan, that was the direction that I was given, that the board did not want to repeat the IASB self-evaluation training module. And then when we brought it back for approval, it was that we had found this other option, which was through CEC, which is a very well-respected organization, discussed what that was, but when I was asked for the topics that he would cover in the first night, I did provide that. And then I didn't hear from anybody after that.
So you know what, we've actually had a lot of discussion on this, and I think, frankly, given board members who are here, we should go ahead and take the roll call vote on these. We can. Sure we can. What do you mean we can't? Of course we can. We have we have a motion on this motion. No.
That's the only question before the...
Yeah, that's all that we're looking at, as presented, not amended, but as presented. And people are free to vote either yay, nay, or abstain. So I'd like to call the roll, Ms. Moe.
Mrs. Butterman?
Yes.
Mrs. Hill?
Vote? Because I wasn't, I mean, I listened, but I wasn't here. Am I
It shows,
supposed
you
to
can
vote?
vote, you're fine.
I listened online.
She can
If
vote.
you're prepared to vote, you're good to vote.
Okay, yes.
Mrs. D'Ambrosio?
No.
Mr. Lobach?
Present.
Mr. Curry?
No.
Mr. Estes?
Yes.
Dr. Bruno?
Yes. Thank you. We have a list of superintendent recommendations. The first one, board policy revisions, second reading and adoption. May I have a motion to approve Board of Education policies as noted in the report as presented? Need a motion?
Motion. Second.
Thank you. Discussion. Roll call, Ms. Moe.
Mrs. D'Ambrosio?
Yes.
Mr. Lobach?
Yes.
Mr. Curry?
Yes.
Mrs. Butterman?
Yes.
Mr. Estes?
Yes.
Mrs. Hill?
Yes.
Dr. Bruno?
Yes. The second item is authorization to prepare the 2020 and 2021 budget. Melissa, I'll turn it to you.
Right. This is really an annual item. This is where the board directs the administration to start the work of preparing for the next fiscal year budget. Eric, anything that you want to add?
Okay.
Annual thing, every year.
Yep. May I have a motion to adopt the resolution directing the superintendent to prepare the budget for the fiscal year 2020-2021?
Motion.
May I have a second?
Second.
Any discussion?
I would like to add during discussion that the budget process and timeline is really NAP, and so we will be working this year to look at that timeline and process to see if there's any minor modifications or revisions. As you know, there have been some big changes in the world of school finance, such as the evidence-based funding model that may change some of the things that happen. So I've asked Eric to take a look at the AP, and just if there's any minor revisions, we'll start it at policy and bring it back to the full board. Just want that AP to accurately reflect the timeline.
Thank you.
And I would just ask that as you prepare the budget, you continue to look for opportunities for savings through grants, efficiencies that also have a long-term sustainability focus, that apply an equity perspective, and that continue to build on the strengths of our effective and transformative programs like dual language, FLAS, PBLs, and inclusion. And when I mention long-term sustainability, I do mean both economically and environmentally. For example, some districts are turning to solar to reduce their energy bills, like Lake Park High School and Romeoville schools. The Future Energy Jobs Act makes that possible to find a developer who can install panels without upfront capital investment, so those might be things to explore. To keep in mind that our community takes pride in our schools and has high expectations for an increasingly individualized and self-directed education that prepares students academically and emotionally for the rigors of Glenbard West and beyond. And after reading Student Voice, which I mentioned earlier, I believe we have opportunities to seek and amplify our students' perspectives, and that should be taken into consideration as the budget is developed. Our district has a long history of being fiscally conservative, and that has served us very well, allowing us to stay in the black during the Great Recession and adapt to the increased demands for the service public schools provide. I think it's important that we continue that conservative legacy, as you have so thoughtfully done in the past.
Thank you, Jess.
Just, I guess, since we're adding to, just I had brought up concern about kind of coming toward the end or coming towards budget time and not having a good look on our staff count. And I believe before we had contingencies to kind of, so that we could have that taken into consideration. This is just strictly enrollment that I'm speaking of as far as staff changes. I believe we had contingency where that would then allow for that to take into consideration during levy time, so that when we come up towards the beginning of school, we kind of know that, all right, we have this already made into consideration. That was my understanding of how, it worked. It didn't really quite work this way this year, so if we could build that in, that would be great.
Eric, you're not, do you know?
Yep,
Okay,
gotcha.
okay, good. Any other comments, questions, discussion? No? Great. Roll call, Ms. Mo.
Mrs. D'Ambrosio?
Yes.
Mr. Lobach?
Yes.
Mr. Curry?
Yes.
Mrs. Butler?
Yes.
Mr. Estes?
Yes.
Mrs. Hill?
Yes.
Dr. Bruno?
Yes. And then finally, serious safety hazards. Melissa, you're up again.
Great. Again, annually, the board must approve safety hazards as those are defined and provided to us from the state as it relates to bus transportation. This is a normal required procedure every year.
Yep. Any other?
Motion.
Very good. Beautiful. Roll call. Any discussion? Yes. None. Roll call.
Mr. Curry?
Yes.
Mrs. Butler?
Yes.
Mrs. Hill?
Yes.
Mr. Estes?
Yes.
Mrs. D'Ambrosio?
Yes.
Mr. Lobach?
Yes.
Dr. Bruno?
Yes. We have other, as we have listed here, board governance, learning together. Melissa, this is an opportunity to review the plan CEC.
Right. So for this coming Thursday, as I had sent out in the email, just to give you an idea of the topics that Dr. Van Clay would be covering, is he starts with defining and working with the board through some activities to get to what the strategic role of the board is. The cascading effect, and that's a new term, so I can't say that I know that incredibly well, but taking it down into strategic vocabulary, the strategic direction of the district, and really that at the end of session one, it's all about building consensus and understanding on the strategic role of the board as a whole, and to help define that work. That's what session one will be focused on. And then depending on how far we get in session one, he'll build session two after that.
Board members, any questions revisiting this?
I've been told it's very hands-on. I did check a reference with another district that he's worked with and got very good recommendation, comments, and feedback from that district.
Go ahead. No, go ahead, please.
Well, I think there's a lot of value in I think the value comes in the fact that we can get together as a total board and discuss the topics that are coming up and have back and forth, which there's just not a lot of time for that otherwise. And so I think that's really what's going to be of the most value to us. And so I think it's important that we all can attend, but I certainly empathize with Linda and Bruce, your frustration about not really understanding that this was committed to in the prior discussion. So I would just say that like we talked about earlier, when we can add on to our board norms and come up with more procedural rules for how we operate together, that this is a point where we need clarity to make sure that we're understanding what we're consenting to and when we're doing it, and that we have a very clear procedure for that, so that everyone is on the same page. Nobody likes surprises, and I don't feel good that that's what's happening here. And so whether or not that's covered in day 1 or day 3 or in the additional 4 hours, but perhaps that discussion of our internal procedures and adding on to those board norms, as we discussed earlier, is part of the whole package.
Well, I just want to say, first of all, Dr. Gay, I mean, I appreciate you spending that time getting the information that board members asked. As I'm coming to understanding, and I don't know if they're maybe already, it sounded like, at this table, that was all the information I have, so I don't know if maybe off the table there was some other conversation about the vision of what a PD looks like, but I'm kind of, after today's additional discussion, understanding now, like, that where people are coming from, which I just wasn't made aware of, because when we're talking about it as an entry plan, as a suggestion from Jess, and then as we're talking about it, there was no clarity on exactly what the PD is, and it sounded more like now you start a workshop, or maybe it's like a board retreat trying to come to Jesus type of thing, but
I don't think so. We won't say that. Let's not say that.
Sorry, maybe not.
Yeah.
Just
No.
come together. Come together.
Come together.
Come together,
That's even-
and such. I just at the, I don't know. I just want to ask that we make sure that we're having discussions openly at the meeting. If I, as a board member, had no idea what we're committing a couple $1,000s to, then, our stakeholders can't either. So, that's all I ask.
Good. Thank you.
And it won't be a come to Jesus.
sorry, not-
No, I get it. I looked hard because your feedback on what you didn't want to repeat from the model that you had been through before. I took that seriously and looked for somebody who was very hands-on activity and not just tell you what to do or not to do. So I don't expect it to be anything like that kind of a model.
Great. Okay, thank you, Dr. Kay. We have also a number of upcoming meetings. Thursday, August 29th, 2019, special board workshop meeting, 6:30 p.m. at CSO, and this is the CEC Professional Development. Monday, September 9th, 2019 is the regular board meeting at 7 p.m. Tuesday, September 10th is a special board workshop meeting at 6:30 at CSO. This is the second piece of the CEC Professional Development. And then Monday, September 23rd, regular board meeting at 7 p.m. And finally, are there any items board members wish to present for consideration to a future agenda? And let me again remind folks that if you think of items, you can send them to Melissa and I to be discussed in the next meeting. I didn't know what, I'm sorry, I didn't hear you.
Well, I'd like to put the approval of expense for Dr. Van Clay on future agenda items.
I think that would automatically be in the consent agenda, correct?
I didn't hear the last part of what Linda asked for, consent of what?
To approve the expenditure of Dr. Van Clay's fee, PD fee.
I think we...
Confused by that.
Yeah.
That's a purchase service that would fall in the budget under the superintendent's budget. So it's different than the Apple testing.
Well, maybe we should have maybe that's the discussion that we should be having about, whether or not it should be a, part of a consent agenda or the approval, because obviously there's some discussion about it.
I think that's more of a legal question, to be honest with you, and I think it was answered. If I'm wrong, correct me.
No, it was answered.
Well, Todd said that that's a separate issue, so we got through the approving the meeting minutes, but it is a separate issue as far as whether or not it should be a roll call approval. I'm just trying to make sure that we're in compliant with the policy. Am I understanding? I mean, you guys are on the board too when we were talking about Apple policy.
With Todd here, maybe we can...
The request is for this to become an agenda item. If that request is being made.
Well,
It needs to be honored, right?
well, but can we take it back to the budget question? Because I think that's the legal question of the difference between ample testing and this. And so this was a budgeted item that's well beneath the threshold of what I could approve. Eric, correct me if I'm wrong. So, and again, not going back, not being here when ample testing came up, I don't know how that transpired, but if we take it on the value of this item, not ample testing, this, it's a purchase service well under $10,000, so that's why it wasn't on
But
the
the
board
problem,
approval.
well, so that was,
That's the problem we're
that we
having.
had,
We don't know what the
that
rules are.
was.
Okay, so that's a
The board members don't know what the rules are.
That reached out
Then
to
maybe-
Todd and our district attorney, and they came back to us and said, no, you need a roll call approval for Apple testing, even though it's under $10,000 for XYZ. I think Ted could probably explain this better, because he pulled up the policy, and,
Right.
you know, so that's the, anyway.
Yeah, so
Maybe we
let me
should,
let-
not to, I mean, I asked for it to be the agenda, so.
And we want to avoid having discussion about the substance. So this is one of the concerns, at least that I have, when we use future agenda items. This way we could get into the nuts and bolts and end up having the discussion here, and it really wasn't on
Well,
the
that's what I'm saying,
agenda.
like, just put it on the agenda, and then we're going to talk
So,
about it.
But the problem is, that
You
we
guys
can't,
want us
we have the schedule for Thursday.
Well,
Exactly.
that's not the issue. I mean, that's part of the issue.
Right.
But the issue is,
And I just want to address it, this has been board practice, and the administration has come forward to the board with various expenditure items over the last 2 years that I've been on the board. There's been different reading programs that have come before the board. There have been various things. I mean, just trying to think back all the various presentations that have been given, and almost every single one of those presentations, they've come in and specifically said, we're here because this is expenditure in excess of $10,000 that requires board approval, and so here we are. That didn't happen with Apple, and it was over $10,000. It was
no,
directed
it
by
was
the
less than,
board.
it was less than.
But it was from the board. Is that
It was from the board.
It was
And so,
from-
given that this is from administration, it's under that $10,000 threshold,
Mm-hmm.
and that's always been what we've been operating under the time that I've been on the board.
But this was asked by a board member to have PD, so,
Can I summarize it a little? I think what Linda's asking for is, can we have an agenda item to
Yes,
talk
to
about
explain.
what is appropriate to be...
That's what I was,
I'm fine with
that's what
that.
I was going to move to.
Be appropriate to what?
Yeah.
Sorry, you got to...
Yeah,
What is appropriate that needs to come to the board for a roll call?
that's correct. And that's what I wanted
That's
to
what you want to talk
put on
about
the agenda,
as far as...
as opposed to
well,
something
honestly,
specific.
I was looking I think there should be an agenda item to approve the expense, but it sounds like there's not,
Well, no, I think it sounds like we were one way with Apple testing and we're a different way now, and I don't understand the difference between what we were then and what we are now. So it's frustrating in the sense that, you know, you need to, I indicated when we were doing that Apple testing change that this was going to cause problems. Obviously, it's causing a problem, so maybe we do need to clarify that, because I don't feel like, I feel like it was definitely one way for Apple testing when Dr. Gordon was here, and, you know, we didn't want to do that. It was only a $3,000 expense, even though we consented to it. And we haven't really, I don't feel like we've consented to this as a board, even though I don't know what budget item you're pulling it from, but I think it should come from board PD or, you know, board, from the board budget. And there's no line item that says Dr. Van Clay on there, just like there was no item that said Apple testing. And so we need to maintain that consistency that we've had. We need to have a board discussion about that. I'd like to put that on future items.
But you're saying that we don't know what the difference is, but we know that the difference is that the superintendent has a budget, and when she makes recommendations, it's knowing that it's within budget based on the budget that's been approved, versus the board does not have a budget. And that was board directed.
Doesn't the
And so
board have
the
a
difference
budget?
is superintendent recommended versus board directed. That is the distinction. So what's not clear about that?
The fact that there was testing. And we had extra money in that budget, but we were told that unless it said specifically in that testing, this is for Apple testing, and there was no, I was told that there was no line item in there for Apple testing and that it had not been budgeted. This also had not been quote-unquote budgeted, that Dr. Dan Clay was going to come here and do this. So I'm just trying to maintain consistency with the way that I was told by legal counsel how we did not approve the Apple testing. It doesn't make sense to me, and maybe
We did, this might help, we did have a line item for Apple testing, but it was for 2 specific grade levels, and we had that budgeted amount. The board wanted to add another grade level that was not budgeted dollars, that we did not have enough money in that account to sustain. That's why we needed consensus of the board, because we didn't have enough money.
We have something like $8,000 left under that budget item. I thought that was...
Yeah.
So Apple testing was a different line item than the purchase service that you were talking about for MAP testing. Those were 2 completely different
Now we're told
accounts.
something.
All right.
So this is the problem. This is the problem.
I mean,
Well,
that wasn't the...
I don't want to, if I can ask board members to cease the substantive discussion, what was and what wasn't. The subject of, it strikes me, of clarifying where roll call votes are needed is consistent with good governance. It's certainly consistent with operating efficiently. And we can, Melissa and I can discuss how we can address these questions about actual roll call votes versus non-roll call votes. If there's some confusion that remains, even if it's just with 1 or 2 board members about it, we can certainly take in advisement. How do we best address that? It could come up and it could be clarified certainly through the PD that we're doing. There could be direction further from council that lays that out that we can consider. And yes, and it could be something that we have a discussion at a board meeting if that's will ultimately be required. But we will have to consent to agreeing to something.
No, I just want to say...
You have to consent to agreeing to something.
I am not confused. I was confused about what kind of PD we're having, because we really didn't discuss what the PD was having. I'm not confused about whether or not we should be approving this. Now, if you, please use your, I'm not confused. So, Todd is right here, so we can ask him.
Okay. Todd, can you?
Let me try to frame the question.
Yeah,
so
that would be helpful.
Okay. So, in the entry plan, with the PD scenario where we got to, we don't want to do IASB, find us some other group, brought that back, provided the summary of what those topics would be. Now, my understanding, because it's a purchase service, and we had the budget to do it, it was by policy, I have the authority to approve that and go ahead with it without having it to come for board action. Now, I don't, with the understanding or the back history on, the Apple testing, what could or did or should have happened, I can't go back to that, but in terms of this item, it was well under what I can approve. It's in the budget. We can schedule professional development out of purchase services. I think the question is, and Linda, tell me if I'm wrong, I think there is confusion, not just by Linda. I think the board would benefit from understanding when the superintendent has the authority to approve purchases and when they are purchases that have to come to the board for approval. And I would encourage this board to do, roll call vote on anything financial, because it seems like the idea of consensus has kind of created some confusion. But in terms of this, I think we need to settle this for today just because it's happening Thursday. So, and that, so is what I'm hearing that the whole board would benefit from understanding when are those times, because there's purchases made every single day that we don't bring to the board for approval. You know what I mean? It falls in the budget, well under what I can approve, versus when does it come to the board?
Todd, but there is, I'm sorry, but there's a little slight, I mean, you have to remember that PD request came from a board member, and there wasn't, my understanding was that it was a request from a board member, so we were looking into PD, and we were just talking generally about the PD. So, I mean, I understand that you came with a recommendation, but based on a request from a board member. Anyway, so I guess it really is, it was initiated by the board. So, anyway.
Yeah, it was initiated by me as part of the work that I hope to do with this board and my entry plan. It was clearly communicated to me by several members on the board that they didn't want to do it again with IASB, but when you start a new superintendent and you have a new board, you do some sort of professional development. So, and maybe that was the part, I'm not sure. It wasn't requested by anybody. It was something that I put on this, my entry plan of work that we were going to do together. But Mark Van Clay was not requested by any specific board member. The direction I got was just not IASB.
Todd?
I think I honestly need to look at the facts. I mean, I'm hearing an explanation, and there's conflicting views of what happened, and I think I need to take a look at it. I think it would be inappropriate for me to give a definitive judgment to your opinion to you this evening. It does, I can say on the surface, if this is falls within the budget and it's under the threshold of the policy, then the advanced approval does not appear to be required. I really need to look more closely at it than this, and I think in addressing the larger question, these facts can be plugged in as an example of how the policy and the requirements of the school code should apply. And we can fold in and compare it. Been asked for a comparison as to why is this different, if it is, from Apple. I think we should address that question as well.
So would the board then be in agreement if we request that legal counsel provides that comparison, takes a look at the particular question, as when we get that information, the superintendent gets that information, we'll share it with the board, and if further discussion is required at a future board meeting, it will be on the agenda as a future, not as a future, but as a...
discussion would be needed anyway.
Well, you may be right. You may need to confirm. Does that make sense? That seemed to be the most effective way to get at all of this. Yeah? No one's in disagreement with that?
Well, I'm kind of uncomfortable having him come out Thursday.
No, but it's not... So I want to be clear. I don't think we're talking about this in the specific sense of... Well, if we're talking about it in the specific sense of the training, Todd?
As I say, I don't have a full understanding of what, how the arrangement has been set for Thursday, what the arrangement is. I can't, in fairness to you, give you an opinion on that.
Okay, it's true. No, I know you can't. No.
And so I don't think this is an agenda item for action this evening, so I'm not...
No, so we can't even...
in a position to take action in any event.
No.
I thought we did. I mean, and I guess I thought we did. I just want to make sure that we have a mechanism to hold Thursday.
Well, we did.
We approved
the minutes
August 12th.
that directed setting that up. So that we did do.
Correct.
Now the question is maybe upon your...
Should that have been the case, right? So I guess it raises a question. Can you take a look at this and be responsive to us prior to Thursday? I'll make every effort to do that.
Prior to tomorrow, because
your Thursday set for 6:30, which means notice will go out by 4:30 tomorrow. Just saying it is what it is.
And if not, we can, obviously, if it's not appropriate that we go forward, we would cancel that. We still have the possibility, depending on the time and what you were to determine, there is the second date that's on the calendar, which could serve as the first professional development if we were to go forward.
I don't know if we would keep that. But I mean, we have somebody here, I mean, I don't want to keep deferring to Eric and putting him on the spot, but I don't know that anybody knows the intricacies of budget and what's allowable any better than he does.
So we're asking Eric, and Eric, you were...
I think this is a really straightforward question, and I think it's troubling to think that, are we going to have to bring every decision to spend dollars under the budget to a roll call vote? I mean, that's kind of what I'm listening to right now. I mean, this is the reason we do a budget based on department level input, is to be able to spend dollars and do things very similar to what we're scheduled to do on Thursday. So I'm a little confused on how that question is still present. So I don't know how to answer the question.
I wouldn't want to have to do that.
Well,
And I said when we got the legal thing about the Apple stuff, that this was going to cause problems.
So what's different now? I guess my question is, why can't we refer to that legal opinion?
Because it said that our roll call, our consensus to approve budget for the Apple testing was no good, and that we had to do a roll call vote, which happened after the board had changed over, and that was a big deal. I mean, that was a big deal protest, and I just want to make sure that we are following that legal precedent. Because if it's good, if it's...
We are.
We are.
But the lawyer is not.
Well, he's not sure about it.
So why would you pull it up and look at it for what it was?
I'm not.
I mean,
It strikes me.
You know, you can't, if you're going to do things that affect, and if you're going to change policies and do these things, then they need to be consistent, okay? And they're not being consistent, and we're not being consistent.
Bruce, that's not, I'm sorry, you've just heard Eric, who has an expertise that dwarfs all of us here, make it very clear to you that these are different, and he is quite comfortable with this. Now, admittedly, Todd is being very circumspect, as a good attorney would be, but I also don't hear him saying, I would not, take the recommendation of your budget director. And it strikes me that how you may think it's a problem, you're bringing it forward, you're saying it's a problem. I'm not hearing the board as a whole saying it's a problem. You have a problem with it, you don't agree with it. But, we talked earlier about understanding where the board was, what the vote was, and accepting that. And I'm confident that my budget director has given us proper guidance. We have a legal opinion that clearly, so why are we continuing to, what is the...
I didn't get legal opinion on it.
He did, but what does it
May
mean?
9th email that was sent to the board.
I'm sorry, Jay?
It was in a May 9th email sent to the board, we all should have it.
What's the opinion?
Todd's legal opinion.
Oh, about the Apple.
About Apple.
Right,
So we
but
have-
no opinion is needed
May
on...
9th email.
What Eric is raising here is that he doesn't understand why any legal opinion would need to be offered on this superintendent expenditure. And I agree, and I don't understand why we're inserting ourselves over and above his expertise. It's mind-boggling to me.
Well, and if it goes back to the Apple testing, and I think that's what it does, then I think when we have, hopefully we won't ever have a scenario like that, because I think getting, and I understand exactly where you're coming from with this, why is this different? And I think understanding the nuances of why it's different and where it falls and which budget line, I get the frustration on it. I think, all I can say is moving forward, I hope that we provide the clarity that the board feels confident in, which is why getting this training done quickly was a priority for me, because it's also responding to just all of the things that I've seen and walked into and trying to pick up and move us forward from. So, you know, I understand that that was a very difficult, you know, that doesn't make sense necessarily within how the budget works.
I really felt that that decision affected the trust within this board, very much so, and that's why you're seeing such pushback from Linda and myself. Now, I think going forward, we probably won't see that, but it was something that the board had directed, and that the board was undermined on that through what I think was a decision that is affecting you now and affecting our ability to move forward. But, you know, these types of decisions, and I said at the time, these types of decisions affect how and what will happen in the future, and they're affecting us now. I don't think anybody's having a good time in talking about this, but the point is if a rule's made, it needs to be followed.
Correct. We have a
I
rule.
just want to make sure we're complying with that policy. I know I'm only 1/7, but, you know, I just deserve all the information, and, you know, this is my understanding of what happened at Apple. That was a new understanding, and so I'm just trying to make sure we're compliant with the policy.
Yes, and all I can say is I'm being compliant with board policy and the directives given to me for a purchase service, and that this was well under that threshold. So, you know, I can't go back to where you were.
No, we don't want you to.
And that's, you know, the board can, first off, you don't have an action item on this tonight. So, but, you know, Eric's interpretation of what I opined on the Apple and his view that that's, you know, consistent with a budgeted item is sufficient for the board to move forward on Thursday. And you know, we'll review it as part of the broader thing and look to advise you whether, in our view, it's consistent with the opinion we rendered on Apple.
Okay.
And this will be, you know, you've had a request to have this as an agenda item, and that's really, again, the only issue before the board right now is whether this is going to be an agenda item, and if the answer is yes, I think that's what Bruce and Linda are asking for.
So that raises a procedural question. Does the board need to consent to putting this on as a future item?
I don't, I haven't reviewed your policy on setting the agenda. You have a policy on the agenda setting for a meeting. I haven't reviewed it, so I can't, again, in fairness, answer your question. I think the answer is there.
In the policy.
Yeah.
I think a board member, my understanding is that a board member has to have something on a future agenda item. And
my recollection is that's what it says, but again,
it depends on the you can adjust the timing, because maybe maybe Dr. Koskowski is busy and needs to do something else, but I think
I asked the question for a particular purpose. Toby, you were called out. I don't know whether you want to take the bait, but if not...
We'll look at the policy. There's a clear request for an agenda item. I think Bruce's characterization is correct, but we'll check it out.
Sure.
Right, so the future agenda item, just so that I can document it correctly, is to explain if this is the same as the scenario in the Apple testing, or if it's different.
I think that's part of the question, and to offer broader guidance on how do we apply the board's policy, and how does the board act. The question is really advanced action versus approval of the bill. How does the board look at that? And included in that will be, is the current policy adequate?
Okay. Can I cease?
We
have direction then? Yeah, okay, clearly? Okay. Then we will adjourn.
Is there a motion to adjourn?
May I have a motion to adjourn to closed session under Section 2C11 litigation when an action against, affecting, or on behalf of the school board has been filed and is pending before a court or administrative tribunal, or when the school board finds that an action is probable or imminent, in which case the basis for the finding shall be recorded and entered into the minutes of the closed meeting. May I have a motion?
Motion.
May I have a second?
Second.
Any discussion? Roll call, Ms. Moak.
Mrs. Hill?
Here.
Yes.
Yes.
Closed session.
Yes. to go-
Mr. Ambrosio?
Yes.
Mr. Lobot?
Yes.
Mrs. Butterworth?
No.
Mr. Estes?
Yes.
Mr. Curry?
Yes.
Dr. Bruno?
Yes. The board will likely not be taking action after closed session.